My lord, there is an urgent matter. With regard to it is under filing process and caveat has been received by the Railway Council. And the livelihood of the more than 184 persons is going to be destroyed by the railway, and they have given for the 15th August, your lordship, for the eviction. From their livelihood, they are the vendors of the platform, your lordship. And this is my request that the matter may be taken tomorrow, your lordship. It is under filing process.
Pick it up today.
It is under filing process, your lordship may.
You want it? We can take it up today.
Fine.
Okay.
May I please, your lordship? My lord, in item number 38, my lord, as per direction of this honorable court, my lord, an additional affidavit to bring on record the election petition filed before the Register of Corporate Service filed, my lord, on 9th of, my lord, this month. My lord, it may be called for my public.
Well, I filed a petition earlier, my lord, maybe notice was issued, my lord, and reading is completed. We have filed it, and I filed it, right? So my prayer is regarding, my lord, acquisition of land by the National Highway Authority, my lord, and that one. So my prayer, it may come on Friday, my lord. Come for order.
May I please, your lord. My lord, I beg to mention item number 32, my lord. This matter has become infructuous, my lord.
And Hawk, Azad.
M. Hussain, my lord.
The M. Hussain, the learned counsel appearing on behalf of the petitioner. Petition has become infructuous. So taking into account the above, the instant petition stands closed as it had become infructuous. Interim orders, if any, stands vacant.
Most of it.
Your lordship, I beg to mention listing a writ petition, lordship. Admission column next week, lordship.
Okay. 21st.
My lord, back to mention for listing of a read petition for orders, my lord. It's a land acquisition matter, my lord. Petition. Yes,
Why orders?
sir, that the respondent be directed to pay compensation to the petitioner.
Why not admission?
My lord, on the last occasion, my lord, the deputy commissioner filed an affidavit that the petitioner has been compensated, my lord, and we were told to acquire instructions, my lord. We have got the instructions, my lord. So
Okay, but why not admission? Has it been admitted?
we did, my lord.
Admitted?
My lord.
Are you sure?
Yes, my lord.
It's admitted? Which year?
This year, my lord. This year.
Then?
2024. 2024.
Is it admitted or only notice issued?
It has been listed twice, my lord. It was last listed on 25/2024, my lord. We were told to obtain instructions, my lord.
Okay, next week, 21st August.
Please, your lordship. Lordship, in item number 22, the petitioner had filed an affidavit on 9th of August. The same may be called for, your lordship. Much of it.
Lordship, same prayer in same item, lordship.
Much of it.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 29, lordship. In this regard, affidavit is required to file, lordship. I am for a private respondent, lordship.
Don't mention these type of matters.
Lordship.
Let's see when the matter is.
Oblige, your lordship. Right, please. Look, I beg to mention on item, my lord, that was last posted on 1/4/2024, my lord. So like this eviction matter, some urgency. Eviction matter, some urgency. It may be listed, my lord.
Next week.
Obligation. Another item, my lord, item number 46 of today's list, my lord. So it is regarding the land taken away without compensation, my lord. Your lordship on that day asked me that if it is listed in the below of the list that I may be mentioned. So it may be upgraded.
2 o'clock.
Oblige, your lordship.
Please, your lordship. I beg to mention for listing of a case on the petition civil for orders.
Next week.
For listing a writ petition, pending writ petition, your lordship. It has been thus posted on 15/3/2024, your lordship, for admission. Next week.
Next week. Later, did you-
One promotion.
अरे इतना matter to ऐसे नहीं तू actually at two no at the top of the list. We'll take up your matter first. Let me take up that matter. Heard Mr. P. Das, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Dev Chaudhary appearing on behalf of the respondent numbers 1, 2, and 3. To stop. The petitioner has approached this court which direction? Connection 9, na?
Page 223, Lordship.
Connection number 6, my lord.
Page
229.
2 to 9.
223, my lord.
2 to 3 or 2 to 9?
My lord. First 223, then 227, then 229.
The petitioner in the instant proceedings have approached this court taking an appropriate read, direction, and order in view of the various authorities directing the petitioner bank in view of various authorities, on one hand, directing the petitioner bank to keep the account frozen, and on the other hand, the respondent number, huh? Who has directed you? The respondent number 3 directing the petitioner to make a demand draft of the frozen amount along with the interest accrued thereon in favor of the Joint Director Enforcement Directorate payable at Guwahati and hand over the same within 5 days from the date of receipt of the letter. Pusto. For appreciating the dispute involved, it is relevant to take note of that the petitioner bank maintains an account of a company in the name and style of MS Analytic Business Ventures Private Limited. Pusto. The Cybercrime Police Station, Kohima, Nagaland had registered one FIR, white crime number 03/2021, dated 8/10/2021, for offense committed under section 420, 120B of the Indian Penal Code, read with section 66, bracket capital D of the Information Technology Act 2000, 2000, na? 2000. Pusto. Taking into account that the offenses under which the said Cybercrime Police Station was registered, police station, the taking into account the offenses under which the case being crime number 03/2021 was registered falls within the ambit of scheduled offenses under the Prevention of Money Laundering Act 2002, for short, the Act of 2002. An ECIR was registered on 12/4/2022 for investigation under the Act of 2002. The petitioner's branch at Pitampura, New Delhi, wherein the account of MS Analytic Business Ventures Private Limited is maintained, received a notice on 19/12/2022 from the respondent number 4, whereby the petitioner was instructed to mark, inverted comma, debit freeze of the account bearing number 922-00034-999-564 as it was required for investigation. Accordingly, the petitioner had followed the instruction of the said respondent number 4 and marked the said account under debit freeze. In addition to that, the enforcement director have been also investigating the said MS Analytic Business Ventures Private Limited. And thereby, the respondent number 1 and 2 had issued various communications to keep the petitioner the account of MS Analytic Business Ventures Private Limited in debit freeze mode. While the petitioner kept the account of MS Analytic Business Ventures Private Limited in the debit freeze mode, the petitioner received a notice, a communication on 19/4/2024 issued by the respondent number 3, dated 12/4/2024, whereby it was informed to the petitioner that the adjudicating authority, New Delhi, had passed an order on 2/8/2023 under Section 8(3) of the Act of 2002. It was also mentioned that the balance amount lying in the account were frozen by the directorate, were attached by the directorate, which was later on confirmed by the adjudicating authority in New Delhi. Under such circumstances, the manager of the petitioner bank was directed to make a demand draft of the frozen amount along with interest accrued favoring the Joint Director Enforcement Directorate payable at Guwahati and hand over this to the Directorate within 5 days from the date of receipt of the said letter. Full stop. The petitioner, upon receiving the said communication, issued various communications to the respondent number 4, as well as the other branches of the Enforcement Directorate, taking into account that there was a direction to keep the account of MS Analytics so-and-so in debit froze mode. However, no reply was received. Under such circumstances, the petitioner therefore has approached this court seeking appropriate redirection and order in view of the various authorities that make various authorities issuing conflicting directions. The matter when the instant writ petition came up before this court on 22/7/2024, wherein when this court issued notice and also sought the instructions from Mr. R.K. Chaudhary, the learned deputy SGI, who represents the respondent numbers 1, 2, and 3, to obtain necessary instructions in view of the conflicting directions. On 10/8, 10, it was on 10? No. On 9/8/2024, when the matter was listed, Mr. R.K.D. Chaudhary have placed an instruction issued by the Deputy Director of the Enforcement Directorate dated 7/8/2024. Wherein it has been mentioned that the respondent numbers 1 and 2 have no objection if the possession of the debit freeze amount lying in the account bearing number 9220034999564 in the name of MS Analytic Business Ventures Private Limited is handed over to the respondent number 3. The said instruction was kept on record and marked with the letter X. This court also takes note of the provisions of the Act of 2002 and more particularly to the provisions of Section 5 and Section 8, wherein the adjudicating authority, 5 is attachment, na?
5 is attached.
Yeah. Wherein the adjudicating authority after a provisional attachment is made had been given the authority to attach. You may let consult. Do you have it, anybody?
Yes, sir.
Has the authority to, after a provisional attachment is being made, to confirm the said provisional attachment. It is seen from a perusal of Section 8.3 that the adjudicating authority (8.3 and 8.4) that after an order is being passed by the adjudicating authority and the provisional order of attachment is confirmed, the director or any other officer and authorized by him in this behalf shall forthwith take possession of the property attached under section 5 or frozen under subsection 1A of section 17 in such manner as may be prescribed. Post- Taking into account the no objections so given by the respondent number 1 and 2, this court and 1 and 2 and the statutory and the statutory mandate contained in section 8(4) of the Act of 2002. This court is of the opinion that the directions so given in the communications dated 12/4/2024, which was received by the petition on 19/4/2024, is required to be complied with. Accordingly, this court therefore grants 5 days' time to the petitioner to comply in terms with the directions so contained in the order dated in the communication dated 12/4/2024. Post-up. It is, however, made clear that the that the amount so remitted to the respondent number 3 by the petitioner bank shall be subject to the trial under the Act of 2002 as mandated in section 8(6) of the Act of 2000 with the above terms.
Instead of 5 days, can it be on 7 days?
7 days.
Obliged.
With the above observations and directions, the petition stands.
Obliged.
Awesome.
Hmm.
I've been newly engaged in this matter.
Huh?
Now, I've been newly engaged in this matter, Your Worship. The order which has been, the impugn order in this particular writ petition, Your Worship, that has been passed by the executive court, Your Worship. Whether a writ petition will be maintainable or not, Your Worship, because the order is of executing court, that is 5/8/2022. 2022. That is the impugn order. Whether a writ petition will be maintainable or not, Your Worship, because the order is of executing court, that is 5/8/2022. That is the impugn order. 2022. 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 That is the imp
G. Bodley? G. Bodley? Mr. G. Bodley, the learned counsel appearing on behalf of the petitioner submits that taking into account that by way of the instant writ petition, an order passed by the civil court had been put to challenge. He be permitted to withdraw the instant writ petition with the liberty to avail to file an application under Article 2 to 7 of the Constitution. Taking into account the settled principle of law that a writ in the nature of certiorari does not lie against an order passed by the civil court. This court permits the petitioner to withdraw the instant writ petition. Liberty, however, is given to avail other remedies as available under law. It is made clear that taking into account that the petitioner herein had, under mistaken legal advice, filed the instant writ petition, the period from 27/9/2022 till date be excluded while computing the period of limitation.
I leave.
Give your names, others who want their names to be included.
But I'm sorry, my lord, I was directed to file the amended post title, my lord, but I have difficulties, so my lord, I could not file on time, my lord. So I may be allowed sometime, I have filed already, my lord.
Learned counsel appearing on behalf of the petitioner seeks 7 days time for filing the fresh memo of parties. First, list the matter again on 28th of August 2024. The petitioner is directed to file their fresh memo of parties within 7 days. The counsel for the petitioner.
My pleasure, Lordship. Lordship, we have filed our additional affidavit, Lordship. Petitioner's name, Lordship, it's page number 29, serial number 26. Particular
Yes,
6, Lordship, Moqsed Ali, Sita Mubarak.
where?
Number 29, Lordship. Serial number 26.
Moqsed Ali. Who is the petitioner? What is the name of the petitioner?
Moqsed Ali, son of Mubarak.
Moqsed Ali.
And the Lordship, right side, the order is there, serial number, same page, Lordship, 20,
Huh?
in same page 29, right side, bottom portion, Lordship, right side column, remarks column,
Serial number?
18, Lordship. Khajna Dolin, Mokoddoma number so and so, Upoproti, Homohorta, so and so, Mote Uttaradikar, Hutre, Potter, so and so, Abdul Rahman, Moqsed Ali.
How? How did your name get inserted?
Lordship, as a legal heir, Lordship.
Legal aid. Okay. That is it. What is your case?
Lordship, petitioner is the patta holder of the land, Lordship,
Hmm.
and the road, they have started constructing a road, Lordship, without giving me any notice, any compensation. I
The
filed
road
representation-
further in Kiraz Miadik Patta of the petitioner belonging to so and so. Hello?
Thereafter, I filed a representation, Lordship, page number 15, praying for demarcation and compensation, Lordship.
Where?
For 15, Lordship, 16 is the vernacular, 15 is the English, Lordship. Thereafter, Lordship, a demarcation.
Benefit on the therefore I'm praying for measurement further and
Thereafter, Lordship, a demarcation notice was served upon me, Lordship, page number 18 and 19. 18 is English, 19 is vernacular, Lordship.
then
Thereafter, Lordship, demarcation was done last page of my petition, Lordship. From it is evident, Lordship, that some portion of land তদন্তকারী সুপারভাইজারি কানুনগ প্রতিবেদন মতে জানা যায় যে উক্ত পট্টার ও দাগর কিছু জমির উপরে সরকারি রাস্তাটু দেখা যায় গতিকে উক্ত তারিখে রাজহুয়া আইন ভঙ্গ হওয়ার আশঙ্কাত উক্ত জমির সীমা নির্ধারণ করিব পরা নগল।
Hello. Heard Miss Swenso, the learned counsel appearing on behalf of the petitioner. Miss M. Bormon appear, Mr. Revenue. Swenso appears on behalf of the respondent number 1 and 2. Miss
3 and 4
M. Bormon appears on behalf of the respondent number 3 and 4. PWD, any PWD council did you see on the way?
Stop over.
Who?
It's already been also. M does. MSM does.
Huh?
MSM does.
He was present today. And so appears on behalf of the respondent number 5, 6, and 7. Taking into account that the respondent numbers 1 to 7 are duly represented, extra copies of the writ petition. Hey, Mr. Bigobul appears on behalf of the respondent numbers 5, 6, and 7. Taking into account that all the respondents are duly represented, extra copies of the writ petition be served during the course of the day. তার আগতে লিখিব issue notice, making it returnable. Madam, we want an information from you next week. On 21st of August 2024. The case of the petitioner herein is that the তার পিছত সেই লাইন কেইটা লিখি দিব নটিছে আগৰ সেইবোৰ ইছ্যু সেইবোৰ লিখিব নালাগে হাৰ্জ. The case of the petitioner herein is that the petitioner is the owner of a plot of land measuring how much?
Entire plot lordship 2 kathas 11 lesser
11 lectures
under Dag number
under Dag number 716
patta number 220.
of covered by KP Patta number 220 of village Lohar Kotha under Mozapur Borkhetri in the district of Nalbari, Assam. It is the case of the petitioner that the respondent authorities, more particularly the respondent numbers 3 and 4, in association with the respondent number 5, 6, and 7, are constructing a road within the land of the petitioner, that too without carrying out any acquisition proceedings, as well as also payment of compensation to the petitioner. It is the further case of the petitioner that the petitioner have filed an application for demarcation, and the respondent authorities have informed the petitioner that the demarcation could not be carried out on account of could not be carried out due to fear of violation of public law and order. Full. Be that as it may, the learned counsel submits that there is a clear admission on the part of the in the communication dated 6/7/2024, issued by the circle officer issued by the respondent number 4, whereby it has been mentioned that the road is being constructed in the land of the petitioner. The learned counsel appearing on behalf of the respondent number 3, 4, 5, 6, and 7 are directed to obtain the necessary instructions and placed before this court as to whether any part of the land belonging to the petitioner is under have been used for the purpose of construction of the road, and as to whether the said construction is being preceded by any acquisition proceedings. 21. Now 4. Yes, Mr. S.D. Puzaister.
In this case,
What is your case?
notice under section 3A of the National Highways Act was issued for acquisition of land in the Hailagandi district lawsuit. As per
What?
the,
What are you challenging here?
what happened, as per the notification,
What order you are challenging? 15/3/2024. Where is it?
Gazette notification, Lordship.
Huh?
Page 59,
notification,
Gazette notification is challenging, Lord.
Why?
lawsuit, what happened? They, after this 3A, they made survey and, after survey, they posted pillar. And this, area of land, it becomes 0.0357 hectare, as per the hectare. But in the notification, they have, there are two notifications they published in the Bengali and in English. The Bengali, they have published against my name 0.0029 hectare, which comes to 6 hectares. And the notification I have annexed is the English, there it is 2029. Page 59, 61 is the relevant
What
part.
is your name?
Somirande,
Where is it? Serial number?
12, page 61.
0.029. Yes.
The Bengali, it is 0.0029. I have.
0.0029. Lesser.
Lesser. Even
Okay.
it is lesser from the actual acquisition. Actual acquisition comes to 0.0357 as per the measurement in this dark number 295. So that's why we have made representation for reassessment and issuing corrigendum to the competent authority as well as to the NHA DCL. This was not done.
Then
I am, and this 0.0357 comes to Lordship 5 kata something. And this 0.029, it is 4 kata something, and 0.029 is only 6 kata. Even if it is correct 0.029, my part of my building goes under this. My residential building, and there is a dairy farmhouse also there. So my prayer is that they may resurvey it and issue a corrigendum. Correcting.
first and foremost, you are basing yourself on certain paper publications. Paper public. The actual will be the 3D notification. What is it? What is there? Just find out that is 0029 or it is 029.
Our price should be 0.0357. So 357.
It is more. So you want to give more land.
More land, they have already posted it. They have posted the pillar. More land, area is more land, but they have.
When did you submit your representation?
26/3.
1/6/2024. Then
Reminder is also submitted.
they are
Nothing.
not doing anything. Yes, why you are not doing? Kala. He has no business. Your business,
yes.
no business.
But he has challenged the 3D notification, Lordship, as per NHA Lordship.
He will look into it. CD which is published in the newspaper is being published. He is only asking for a correction. Why you are not doing it?
Lordship, no copy has been served on us, and our name has not also been shown.
Huh?
In this matter, our name has not been shown, my lord. Government.
You are not serving it?
We have served.
No. Service personnel.
Name is not.
Deputy Commissioner, we have served.
You serve a copy. And madam, you get your instructions on this. on these representations. Like this. GSM has received it 6/8/2000.
We have missed them, my lord. Name is not shown. I am sorry for that.
Hmm?
I'll have the instruction.
Okay, then we do one thing. Service has already happened, so obviously then I'll issue notice.
Yes, yes. Showing our,
21st you get this.
my lord. I'll try.
Notice making it returnable on 21/8/2024. Full stop. Mr. Union Kepukan. Ms. Kepukan appears on behalf of the respondent number 1. Ms. So-and-so appears on behalf of the respondent number 2. Mr. R.K. Talukdar
For 3, my lord.
for 3. And Ms. 3 and 7.
Yes, sir.
3 and 7. And Ms. M. Bormon appears for the respondent number 4, 5, and 6. Taking into account that all the respondents are duly represented, extra copies of the requisition be served upon them during the course of the day. The grievance of the petitioner in the instant proceeding is that although 0.0375 hectares of land was surveyed and pillars erected pursuant to a notification issued under Section 3A of the National Highways Act 1956. But at the time of publication of the notification under Section 3D, which is required to be published in 2 newspapers, of which one is in vernacular, there are conflicting areas being published in the said newspapers. Mr. S.D. Purkayastha, the learned counsel appearing on behalf of the petitioner, submits that in the Bengali newspaper, namely,
Jugo Santosh.
Huh?
Jugo Santosh.
what?
Jugo Santosh. Jugo Santosh.
Namely so and so, the area of land against the petitioner's name have been shown as 0.0029 hectares, whereas in the English Daily, namely Eastern Chronicle, the land of the petitioner has been shown as 0.029 hectares. Full stop. The petitioners thereupon have submitted representation and reminders to the respondent number 5, 4 and 5. However, for issuance of a corrigendum, however, nothing has been done in that regard for which the instant with petition has been filed. Full stop. Ms. So-and-so, the learned counsel, Ms. M. Bormon, the learned counsel appearing on behalf of the respondent number 4, 5, and 6, shall apprise this court as regards the discrepancies in the 2 newspapers as regards the so far as the notification under Section 3D of the National Highways Act 1956 so issued. Full stop. Mr. R.K. Talukdar, the learned counsel appearing on behalf of the respondent number 3 and 7, is also directed to produce the gazetted 3D notification, a
That al-
photocopy of the.
That already annexed, my lord.
No, that is a newspaper.
Lords.
As the gazetted 3D notification on the next
Peti-
21/8, huh?
Petitioner may provide that vernacular version of the newspaper, my lord, for my easy reference.
I will file additional.
It is not annexed in the writ petition.
Give a copy. You have a copy? Or did you make the submission just for the sake of it?
It is there.
No. What is that?
It is that vernacular, well, that discrepancies has been arising.
This is which newspaper?
This is from Yugashankar. Yugashankar.
Is that a newspaper?
Yes, it's from newspaper by.
Bengali version.
Bengali version.
This is not a gazetted one.
Gazette Lordship.
It was published in newspaper.
Here, what is the area soon?
0.0029. Much of it.
Yes, what is this?
I'm telling the order at page 28, my lord.
Where is appearing?
A so cause notice at page 27, my lord. The ground of so cause notice and the ground of order are totally different, my lord.
Where is your suppose?
My lord.
7. Rule 21A, person does not conduct any business. You file reply?
Not the file, my lord.
No reply filed. Person other than paying tax on the year failed to furnish returns for prescribed period.
Lordship will also see, my lord, so cause was issued by respondent number 3 and order has been passed by respondent number 4, my lord. Covered by lordship order at page 46, my lord.
Mr. Gogoi, we set aside this and allow you to do freshly.
She will give me at least time till Friday.
Why?
Let me have the inspection.
No. When you put a particular ground in the so called, the reason has to be that only.
No, why I'm saying is, madam, might be, madam, there is another so-called that has been issued. At least for
This is
that.
mentioned there, na? What so called it is mentioned? Kindly see the so called of 22/6/2023.
Madam.
Oh,
Because that are same, my lord, 22,
Same, na?
22, 623.
it can't be unless you see my order, last order. Unless I
No, I've
keeping this-
seen it.
You are still given the liberty. Makes it clear that the setting aside of the order by way of the instrument shall not in any manner affect the right of them to take a procedure for cancellation by issuing proper suit. Go ahead. Give the date. Set aside. Allow the petition. It to the page 47 order to. Kali date kita say. Give the dates properly. Go ahead.
Yes, all are responding.
This so-called cancellation has become a mockery.
Because of this, probably because of this online format, madam.
Understood, but then also you have to apply your big mind. Then why you are issuing a so-called? Therefore, the order also deserves to be passing this manner.
May I please, your lordship? Your lordship, in this matter, the petitioner is a small street vendor, your lordship, who used to sell vegetables, fruits, or sometimes tea. Your lordship, 16/7/2024, the eviction notice issued by the circle officer Sonapur Revenue Circle, alleging that she has encroached the roadside reserve land, your lordship. But in that eviction notice, your lordship, the Sonapur
Whereas multiple complaint pertains have been received from the Air Force so and so. LR report that it landed the reserve without any order to vacate. And you're gone.
So, your lordship, on that eviction notice, they didn't mention any time period, your lordship.
Huh?
They didn't give any time to my client, your lordship, to remove her stall or to arrange some other income source, your lordship, because she has no other income source other than this small small.
What stall you were having?
Your lordship, I have a stall of fruits. I have sell fruits, vegetables on that stall.
Huh?
I have sell fruits, vegetables, or sometimes tea on that stall, your lordship.
E.
Tea.
Okay. Buy one vehicle which moves around, na? Why do you need a place?
No, your lordship,
You have been already evicted. So what remains? What do you want?
according to the Street Vendors Act,
Street vendor?
Street Vendors Protection of Livelihood,
Where is it? Where is this done? Hunapur. Hunapur, you have Street Vendors Act. Can't keep on, have your, yeah, wherever you want, you can't keep it, put it out there in the peril of the people. Okay. Show me where is that, what right you have? Did you take any permission from anybody? Huh?
your lordship,
By a counter table, keeping LPG cylinder, table, crates, chairs, etc., and also closing your stall, you have started covering all these items with a tarpaulin and have started occupying this area on permanent basis without any ownership over the area. You are also washing utensils and throwing waste and garbage in and around. In such an activity, you are advised not to set up any tea stall on the temporary permanent basis and you are requested to shift to any other. However, you did not agree. It must be ordered that during interaction with the Air Force, personnel offered to remove the stall and if you or your daughter are employed. So, well, then what happened in the hearing?
your lordship,
What right you have?
Your lordship, there is a renowned judgment of Honorable Supreme Court of India, your lordship, that is Maharashtra Ekta Hawkers Union and another versus Municipal Corporation, Greater Mumbai and others. Here, your lordship, your lordship, the Honorable Supreme Court has clearly mentioned that street trading being a fundamental right has to be made available to the citizens, subject to Article 19, subclause 6 of the Constitution, your lordship. And on that basis, your lordship, on that
Was the Supreme Court considering roadside reservation land?
no, lordship, that is not considering roadside reservation land. And
That is the case in Bombay. You have the Street Vendors Act out here. This was prior to the Street Vendors Act coming into.
yes, your lordship.
On the basis thereof, the Street Vendors Act came. Now, were you allotted any place by the authority?
No, your lordship. Because your lordship, there is no any survey happens by the concerned authority, your lordship, regarding whether which place is allotted for any street vendor or not.
Mr. Counsel, those things do not appear. You cannot set up your whatever you feel like you just have your office out there and then to remain out there. What right you have opening up a stall wherever you feel like? Go and open a stall wherever you feel like. Go to some village out there. Open it. You are putting her on the road itself. Where is this? This seems to be somewhere nearby that Hunapur check gate, na?
Is,
Where there is a market on this side. and on the right hand side, you must be doing on the way where you go to the Digaru.
Yes, Your Lordship, it is in front of the airport station, Digaro.
Why?
But it is on footpath, Your Lordship, no,
Footpath.
outside lane, Your Lordship.
What is this? You can't have it. You want, okay, open there. Have you got any license from anybody?
No, Lordship.
Then
No license. is
You
issued.
can't have anybody, because if we allow you, everybody will come. There won't be an end to it.
Then, Your Lordship, the concerned authority must issued some license to this vendors, whether they can
Take a license somewhere, do the business somewhere properly. This is not the way you are doing. Take a license. I think this is the Gaon Panchayat area. So take a license from the Gaon Panchayat, do a business properly. You can't do a business anywhere, open up a shop anywhere, and then you remain out there. Earlier, you were allowed by the Air Force to remain it, but you made it from a small one, you made it very big. See, what did the Air Force allow you earlier? Kindly see. The Air Force allowed you to do a particular thing from a particular, say, you have been selling like fruits and vegetables there by keeping items on the ground on the floor tarpaulin and clearing the complete area in the evening as being done by the other street hawkers on daily basis and during Saturday market. This was permitted. But then you slowly start starting a shop. Yes. What did you do? Having utensils, making a hotel, like keeping chairs. Then this type of
Your Lordship, I never constructed any farm.
you have no business. You want to go there and do some business which you are permitted, you should have done it. You can't keep on doing all these things. But what did you do? With the above activity, you started occupying the area by a counter table, keeping LPG cylinder, table, crates, chairs, etc. And after closing your stall, you have started covering all these items with the tarpaulin and have started occupying this area on permanent without any ownership of the area. This is what you have done. Other street hawkers were there, they were doing. You cannot do like this. This is absolutely incourageous. Hello, let us dismiss this case. First dismissal of the day. Yes, your name, so and so, appears on behalf of the petitioner. Miss Embormon.
1, 2, 3.
My goodness. Appears on behalf of the respondent numbers 1, 2, and 3. You appear for the Air Force? So and so, Mrs. Burwa appears on behalf of the respondent number 4. The petitioner is aggrieved by the actions on the part of the respondent number 2 and 3 in evicting the petitioner pursuant to issuance of a notice dated 16/7/2024. It is seen from the materials on record that the petitioner earlier used to sell items like fruits and vegetables, etc., by keeping items on the ground on a cloth oblique tarpaulin, and thereupon used to clear the complete area in the evening, as was being done by the other street hawkers on daily basis and during Saturday night market. The Air Force Station Digaru, before whom Digaru did not object to the said selling. However, the petitioner slowly started to use the said area on a permanent basis. Inasmuch as the petitioner started occupying the area by counter table, keeping LPG cylinder, table, crates, chairs, etc., And after closing of the stall, the petitioner started covering all these items with the tarpaulin and started occupying the area on permanent basis without any ownership of the area. In addition to that, the petitioner was also washing utensils and throwing waste and garbage in and around that area. Under such circumstances, the Air Force authorities requested the petitioner not to do so. However, the petitioner did not agree to the same. It is under such circumstances that Air Force authority had to approach the respondent number 2 and 3, taking into account that the petitioner was trying to set up a permanent establishment in the roadside area. Pursuant thereto, the notice was issued to the petitioner on 16/7/2024, and the petitioner subsequently was evicted. The learned counsel appearing on behalf of the petitioner submits that the petitioner has right to vend by setting up a stall in and around that, say, setting up of a stall, and the state ought not to have evicted the petitioner from the said area. This court, upon perusal of the materials on record and seeing that the petitioner had no conceivable right on the basis of having no conceivable right on the basis of any lease or ownership, lease or license, could not have set up a permanent like structure, establishment on a roadside land. Under such circumstances, the eviction of the petitioner on the basis of a notice issued on 16/7/2024 does not call for any interference. Accordingly, the petition stands dismissed.
May I please, your lordship?
Yes, Mr. D.
Simple pair, my lord. The petitioner passed the NEET examination, my lord. He belongs to OBC Moria community, my lord. And she passed the NEET examination, and thereafter date of my lord counseling is fixed on 14th August, my lord, with effect from 14th August. And
Why have you
my lord,
approached this court so
my
late?
lord, page 25, my lord.
Yes.
She has filed an application before the deputy commissioner Vishwanath to sign the caste certificate, countersign the caste certificate, my lord. That has not been done. My lord,
Who has
that
given
was
the caste certificate?
caste certificate.
Where is the caste certificate?
It is mentioned in page 12, my lord. P1. And it
P8. P8.
P1. Page
Page 24.
Page 24 is the, my lord, this is the caste certificate submitted before the deputy commissioner to.
You want that signature there, countersigned by the
DC,
DCSDO.
my lord. That was not done, my lord, since July 2016, my lord. 16 July 2024. And the counseling date is fixed with effect from 14th of August, my lord. Have you
Understood, but why have you approached so late?
noted that?
When will this court pass a direction? Today is what, 12th? Counseling last date is 14th.
Starts from 12.
So you still have time. Madam, short notice 21st. Issue notice making it returnable on 21/8/2024. Ms. M. Bormon appears on behalf of
14th August. Counseling will be started. 14th August. last day after tomorrow.
So what?
If I cannot produce this certificate, my lord, before the counseling,
That is why I asked you, why have you approved so late?
my lord,
Why have you approved so late? Your answer was that 14th it is going to start. Then,
I'm sorry.
yes,
I'm
you
sorry.
said that.
Sorry.
My specific question therefore was, why have you approved so late?
My lord, since
Why?
since the application is given, my lord, on 2nd August 2024, my lord. And
No, the certificate was signed by that person concerned on 26, 2024. So, they did not sign it in the month of July. Okay, so you gave it on 1st of August. Why did you approach this court on 7th and file this writ petition and didn't care to mention?
my lord, I have mentioned, but due to some problem, my lord, it is not listed.
What?
Friday, my lord. I have not mentioned here. Some problem is there, an official problem, my lord.
What official problems?
That's why.
You did not mention, because if I am taking up this matter, I didn't see your face mentioning.
Kindly consider, my lord.
What
Otherwise,
consider?
is-
Nothing
is-
considering.
and there
You
is-
have delayed it. This court, is this
And-
court have no other business?
My lord, entire career will be.
So what? Carriers will come next time she will appear.
My lord, kindly consider, my lord.
No. Nothing doing.
My lord, kindly consider this.
He has to get the information. When was this matter placed before the DC? When?
This is submitted on 16th July, my lord. 16th July 24.
So 16 July 2024 it was given.
Did it many times, my lord.
So then why didn't you approach this court immediately in 1st of July, August?
Impression that, my lord, DC will countersign it, my lord. There are 4 people, my lord, will to obviously of community, my lord. They are not well aware the.
Well, issue notice making it returnable on 14/8/2024. Ms. M. Bolman appears on behalf of the respondent number 1 and 2 and accepts notice. Extra copies of the writ petition be served upon her by 1 o'clock, by 12:30 of today. Post. The petitioner herein had appeared in the which exam?
NEET, my lord.
Huh?
NEET examination, my lord. Kindly,
Had appeared in the National Eligibility Cum Entrance Test bracket UG-2024 under the OBC-NCL bracket close category. What is NCL?
non-creamy layer certificate.
Post. A certificate, full stop. The Viswanath District OBC Association had already certified that the petitioner belongs to the other backward classes. Full stop. However, the said certificate is required to be countersigned by the DC/SDO of the concerned district/subdivision. It is the case of the petitioner that on 16/7/2024, the certificate of caste of the petitioner was placed before the DC/SDO of
Vishwanath district.
Viswanath district. However, as nothing was done, the petitioner submitted a representation on 1st of August 2024. Taking into account that from 14/8/2024, what is that, counseling?
Document verification and public counsel.
Document verification and counseling into the medical colleges. NEET is medical college. Medical colleges would start. In spite of the said representation, nothing has happened, and as such, the petitioner has approached this court. There's the this court directs taking into account the said aspect to the matter, this court directs the district commissioner, Biswanath, to forthwith verify as to whether the petitioner is entitled to the certificate of caste and if so, entitled the counter signature be made. It is however observed that if the DC, if the respondent number 2 is of the opinion that the petitioner is not entitled to the said caste certificate, reasons of the same be intimated to this court by way of instructions on 14/8/2024. So a copy of the instant order be served by the certificate copy logalog পাই যায় নে? Be served upon the a copy of this order be furnished to Miss M. Bormon, the learned standing counsel of the learned counsel appearing on behalf of the respondent number 1 and 2 by 2 p.m. by the court master of this court. And further, the petitioner is directed to serve a certified copy of this order to the respondent number 2 at the earliest.
One.
Yes, what is this?
Lordship, I have
What
filed.
is this? Aadhaar? Your name is not there. Huh?
They have taken biometrics, my lord.
Issue and directing is to issue for issuing Aadhaar to the petitioner's son, Sabbat on the basis of biometric taken on so and so Iman within that time. And they will say that what matter is pending in the Supreme Court. That is your submission.
On the basis of SOP, on the basis of SOP issued by the Registrar General of India and approved by the Honorable Supreme Court, the Aadhaar numbers are kept in hold, on hold. Petitioner's son.
Huh?
Petitioner's son's Aadhaar number was kept in hold. Yes, Lordship, because of the SOP issued by the Registrar General of India.
Where?
Yes, this, I have affidavit filed today, Lordship, today morning. But it is not on record.
But why everything is happening? No notice has been issued.
Notice not issued, Lordship.
Huh? This happened in 2018. Now what is happening?
Page number 18, my lord. They have taken biometrics, my lord, 11/6/2019.
Huh?
Taken biometrics, my lord, 11/6/2019, my lord.
No, it's okay, but what is happening all this while? You can't be a basis of a 2018.
Yes, for 16.
Why do you need the Aadhaar?
Need, my lord. Need exam, my lord.
Huh?
Need exam, my lord. They have mandatory. It is mandatory, my lord.
Need they mandate Aadhaar? Without Aadhaar, they don't give.
No, circular is there, Lordship, with the, there is a circular also there, without.
No, they cannot impose
No,
upon you the Aadhaar. There's a 9 judges bench which says that you cannot be imposed with an Aadhaar.
registration, my lord.
Have the government now overruled the 9 judges bench? Wherein it says that Aadhaar is not mandatory.
No.
It is there.
No, is it there? Is there?
Yes. Where? The state government may follow the 7th amendment. The council may first identify the scheme. For the What does it mean? No, these are nothing to do with the where is it said that it is requires the Aadhaar?
Page
The
number
second
66,
page,
my lord.
that's
Page number 66, my lord.
Huh? Page number
The deed petition, my lord.
16. Where?
My lord, page 60 is the last line, my lord. To log in is issuing an Aadhaar enrollment number.
Where?
Page 66, my lord, for
60?
6. For joint entrance examination, my lord.
National Testing Examination.
Page 66, my lord, there. For logging in joint entrance examination. My lord, this is also last line, my
Page
lord.
66.
Yes.
Where?
My lord, last line, my lord, to log in using Aadhaar enrollment number.
To log in, create a
Yes.
DigiLocker.
My lord, this is a registration process.
Anyone. You can even give your passport number, PAN card number.
My lord,
Why do you need that Aadhaar? That is why.
my lord, so far Aadhaar.
Why there is or? Don't come up with all these things.
No, not only for this, my lord, but Aadhaar is required for, my lord, getting the benefits under the scheme, my lord.
No, not necessary. Now
Yes.
that if you have the enrollment number, you can give it. I have already, there are many the notifications to that effect. Don't worry.
My lord,
You should
moreover,
notice. No, there is no urgency with these type of matters.
no, because my lord, other family members, they are already been issued with the Aadhaar card, my lord.
Fantastic.
His father, mother, and the younger sister also. my lord.
Okay, change the name, change your photo, everything, and then get another one. Yes.
No, that's correct, my lord, but they have taken the biometrics, that should be come to a logical end, my lord. Because as per section 9 of the Aadhaar Act, my lord, there is no connection with, my lord, NRC. Kindly see, my lord, page 39. Page 39.
Anyway, we'll issue, the matter has been pending since long.
My lord, therefore, my lord, that may fix, my lord. In the meantime, whatever.
Issue
the-
notice. Issue notice making it returnable on 2nd of September 2024. Ms. Esbulwa appears on behalf of the respondent number
all it's for.
1, 2, 3, 4,
5 and 6.
5. Ms. Embolman appears for the respondent numbers. 4. 5 and 6, madam, you are appearing, no? 5 and 6, yes. Taking into account that the respondents are duly represented, extra copies of the writ petition be served upon them during the course of the day. Full stop. Ms. Esbulu, counsel appearing on behalf of the respondent numbers 1, 2, 5, 4, duly submits that the affidavit on behalf of the petitioner, on behalf of the said respondents are ready and would be filed during the course of the day.
Already filed. Lord.
Have already been filed. Full stop. The petitioner herein would be at liberty to file their reply. Full stop. On the returnable date, an attempt shall be made to dispose of the petition.
Obliged. Thank you.
I'm sorry, my lord, on the last occasion, I could not phrase the matter properly, your lordship. My lord, your lordship may kindly come to page 32, my lord. The summary of proposed notice, your lordship. And the reason, brief fact of the case is non-declaration of correct tax liability. And your lordship may kindly see page 33. It says, my lord, so cause notice is attached, but no so cause notice was served upon us, your lordship. And this summary of so cause notice was given, my lord, the day when the tax was determined. That can be gathered from page 37. Page 37. Here at the top, they have written even date, my lord, 28/9/2023. And summary of so cause notice date is same, your lordship, 28/9/2023. Meaning there, my lord, prior to my lord issuance of this circular, my lord, we have not received any so cause notice, your lordship, number one. Number two, my lord, as per subsection 4 of section 75, my lord, before issuing any adverse order, my lord, an opportunity of being heard is required to be given to the.
You have given a reply at page 38.
So far as this summary of so cause notice is concerned, summary of so cause notice. But against this reply also, my lord, page 39, my lord, what reason they have given, my lord? If, when assuming we are considering it reply to that, my lord. In fact, there is no so cause notice. In fact, reply received from taxpayer is not satisfactory. My lord, how, what is the satisfaction? On what basis it is not satisfactory? Moreover, your lordship, in the order, page 41, your lordship, a so cause notice statement, no date, my lord, nothing is there, my lord. No reason assigned, my lord. So, my lord, when the same question came up before Honorable Chhattis High Court, my lord, Honorable Chhattis High Court, my lord, if your lordship, Chhattis High Court held, my lord, that the statutory requirement before passing any adverse order, my lord, an opportunity of being heard has to be given. Your
Hearing.
here, page subsection 4 of section 75 says that I have quoted page 15 of my writ petition.
This is done under what provision?
Page 73, section 73, your lordship.
The section 73 visualize a hearing.
For passing order under section 73, first one notice is required to be given. And if the authority is passing order adverse to the, my lord, before passing order, my lord, an opportunity must be given. In that case, my lord, notice was given, but compliance of section 70, subsection 4 of 75 was not done, your lordship. In that context, my lord,
Now, where have you sought for personal hearing?
my lord, we have not sought for. If we have not sought for an authority is going to pass adverse order, in that case, your lordship will see an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty in case of so cause notice or something like that, or where any adverse decision is contemplated against such person. In that context,
In this case, at paragraph number 10, it is categorically mentioned that the appellant therein have sought for personal hearing.
my lord, so cause notice was issued in that case. Here, my lord, summary of
So cause notice, you have given a so cause reply. And what is your reply? That as the central government is looking into it, you kindly drop
But
the
my lord,
proceedings.
if my lord, under subsection 1,
You need not say that this is the amount and that is the amount.
in detail, we can furnish your lordship if the
Yeah.
proposed
Yeah.
notice is given. your
Did you say that we did not receive the so cause notice?
In petition we have said, your lordship.
No,
First
here,
time- My lord, first time we have received on 28/9/2020.
so there, did you say that?
After receipt of that, because your lordship, it is reflected
You
that
submitted your reply, did you
on
say?
31st/10,
No, Mr.
23.
Goel, did you say that? That, look here, we have not received the attached SOCOS. There is no SOCOS.
we have attached the notice issued by DG. But my lord, in my humble submission, my lord, if the SOCO notice would have been given to us, my lord, we can place our case.
It is already there, seeing that the SOCOS notice attached. You did not say anywhere that the SOCOS notice which you attach is not a part of it.
But my lord, if the fact remains that no SOCO's notice has been issued,
Fact doesn't remain that. Fact will be on the basis of something to be there.
then
Why
the
should this
petition,
court go into a fishing, roving or
my lord,
inquiry?
in the writ petition, we have on oath, my lord, we have given specific
Do
statement.
what? And you have woken up now.
Then, my lord,
Why? After 8 months?
but my lord,
Okay, we can issue rule, no stay. We'll have it after 5-7 years,
if my lord instruction may be like earlier case, sought for. my
and the
lord,
matter will be pending,
no problem.
and then you would not get the benefit of 128A.
But this is not a case of 16(4), your lordship, that it is case of 16(2)C, your lordship. The last occasion, it was not placed correctly, your lordship, by me, my lord. It is case of 16(2)C. Page 30. Everything was done, my lord, on time, your lordship.
A simple reply is kindly don't initiate any action because under 6(2) the central authority is doing. That's it.
But in the portal, my lord, space is limited. If the SOCO notice, then we can give it. In fact, your lordship will see page 16. I have quoted page 16.
Then why didn't you write out there that
The
we
taxpayer
are
has
going to
not
give you
agreed
more
for
than
the
that?
Regions cited by the taxpayer disagreeing, partially disagreeing. There are the regions cited the taxpayer for disagreeing, partially disagreeing. Reply received from taxpayer, no reason, my lord, only said not satisfied.
Kindly see one thing very interesting.
Fine.
Page 38.
38.
Yes. Therefore, the undersigned requests you to kindly drop the matter and oblige. A copy of the SOCOS notice issued by DGI is attached. And then you say that we received the SOCOS
My
notice.
lord, this is by central CGS. This is statement. The copy which we have received from the center, that was attached. DGGI. This is the.
Yes, Mr. Gogoi.
Here, I will have to see instruction available. Suppose-
If you see the SOCOS reply
Lordship.
at page 38,
Yes, ma'am.
option for personal hearing, he has ticked it.
Yes, Tickmark has been given.
So thereby he sought for personal hearing.
Got
Did you give it?
That my lord, okay, okay. On Friday, my lord,
As you have the option, that means you would normally have you give it.
Yes,
But the
we'll have to
question,
give-
did you give it?
that my lord, I can apply for.
Or Mr. A. Goel, the learned counsel appearing on behalf of the petitioner. The B. Gogoi appears on behalf of the 1, 2, and 3. As the respondents are duly represented, extra copies of the petition be served upon him during the course of the day. The case of the petitioner in the instant proceedings is that the petitioner received a show cause notice dated 28/9/2023. In the said show cause notice which was issued, in the portal, it is also mentioned that the show cause notice is attached. Further to that, it has also mentioned that the date of reply to be submitted is on 27/10/2023. To the said show cause notice, the petitioner submitted the reply on 31/10/2023, wherein it has been mentioned that the DGGI bracket CGST bracket close had also initiated proceedings of inquiry in 2020 and determination of tax regarding output liability and eligible ITC for the period up to a period covered under the DRC 01 was going on. Under such circumstances, in terms with section 6(2)(b), it was stated that the parallel proceedings on the same subject matter cannot run, and as such requested the state GST authorities to drop the said matter. It is also seen that in the reply to the show cause notice in the option, the petitioner have taken the option, have chosen the option for personal hearing. Be that as it may, on 30/12/2023, the respondent authorities have passed the order directing the petitioner to make payment, failing which action would be taken. The counsel for the petitioner have challenged the said impugned order dated 30/12/2023 on two grounds. First, there was no, the show cause notice was, as well as the order so passed, is not signed by any authority. Secondly, it has also been alleged that the petitioner specifically sought for personal hearing. However, no personal hearing was granted. And as such, the order so passed is also in violation to the principles of natural justice. The learned counsel appearing on behalf of the petitioner had drawn the attention of this court to an order passed by the Division Bench of the High Court of Chhattisgarh in writ appeal number 172/2024 in the case of Mahendra and Mahendra Limited versus Union of India, wherein the Division Bench of the State Court had observed that when the statute mandates an opportunity of hearing to be given, not granting the same would amount to violation to the principles of natural justice. Taking into account the above, Mr. B. Gogoi, learned counsel appearing on behalf of the state respondent submits that he would obtain necessary instructions. Issue notice when?
Lordship will give a short date.
Short date
Next week,
on
Friday.
21st. Can you do it? Issue notice returnable on 21st, huh? Taking into account the above, this court is of the opinion that pending instructions to receive from the respondent authorities, the petitioner is entitled to certain protections. Accordingly, this court directs that the respondent authority shall not take any coercive action against the petitioner till the next date. No, not same.
63.
Yeah, what is this?
Here, Lordship. Page 22, summary of proposed notice. For the same period, Your Lordship. And we have given reply that Your Lordship will find at page 26, my lord. There you go.
Mr. Gogoi, tell me one thing. What is the period ending for 30 up till 17, 18?
It will be March, March 18.
3 years?
Yeah, yes,
3 years.
yes,
From the date it is short paid.
yes, my lord.
Short paid would be, it will be ending by 2021. Did you extend by exercising 168A?
Pursuant to this notification of the central government. Page 33.
Or do you take the shelter of under section 11?
So probably they have taken, because otherwise, my lord, it will be time barred.
He is going on another thing. But the question is whether you have done it because this is under another act.
Absolutely. Regarding adopting this particular notification.
Because you need to pass a similar order. Because if you say that you will take the shelter under 11(1) of the AGST Act, it cannot because 11(1) has to be only in terms with 11(4).
There also I will have to sing instruction. My lord. For all probability, my lord, they used to adopt whatever is, my lord, issued by the central authorities. By state government.
You can't adopt like this.
Will have to be
It
some.
has to be recommended. Did you ask for? Because you have a separate act
Well,
unless, because if you see the AGST Act 11, so Yeah, anybody has the AGST Act? What is this? You don't have a book?
Okay.
Section 11 say power to grant exemption from tax. Where the government is satisfied that it is necessary in public interest to do so, it may on the recommendation of the council by notification exempt so and so. 4 says any notification issued by the central government on the recommendation of the council under subsection 1 of section 11. That is for exemption, granting of a or under subsection 2 of the section of the central area shall be deemed to be as a notification as the case may be as an order issued under this act. 2 says where a government is satisfied that it is necessary in public interest to it may on the recommendation of the central council by special order in each case under circumstances of exceptional nature to be stated in such order exempt from payment of tax any goods or services or both of these. It does not include extending.
Also.
How do you take,
Relates to the exemption.
huh?
It relates to exemption.
How do you take care of that?
And I will clarify.
Where the central government is satisfied that it is necessary in public interest so to do so may on the recommendation of the council by notification exempt generally either absolutely or subject to such order as the condition specified therein goods or services or both of any specified description from whole or any part of the tax leviable thereon with effect from such date as may be specified in such notification. So it is an exemption of a tax.
Well,
So if the central government gives, you can very well adopt. It will apply. This is why you then also, if you remember the case of butter traders, which I was taking up, in that case, there was in respect to this agricultural cess and all, which is to be collected, you gave an exemption at the central government and accordingly you adopted by way of a notification. Did you for this, because 11.1 to, because if I remember in the series which I have taken up on 21st, there's a series coming up. So in that series, one joint commissioner had given something. They are saying that we have not issued anything, but we are adopting in terms with 11.4. But 11.4 is only for 1 and 2. How do you take care for 4?
one and two.
Then
Deemed to be a notification.
how do you take care for extending the period of limitation? Because when you came up in the AGST Act, 168A was not there. COVID was not there.
Yes.
Unless you insert a provision, something you cannot do that. এই আগৰ হেতুত এটা আৰু এটা লাইন লিখি দিব আগৰ অৰ্ডাৰটো Mr. A. Goel, the learned, you have not taken that ground, na?
My lord, this is legal ground, my lord, can we take? And what, my
Legal
lord?
ground. Huh. Oh, it's not okay. Should have taken this type of ground.
In fact, time limit, it is barred by limitation, that do not have taken your lordship. Order passed under section 73 is barred by limitation that I have taken in my petition.
The AGOL, the learned counsel appearing on behalf of the petitioner further submits that the order, the notice which have been issued under section 73(1), as well as the order dated under section 73(9) of the Assam GST Act is also barred by limitation. Inasmuch as the period for issuance of such notice is 3 years, na? 3 years from the date on which the amount is short paid. What is that? Years from the date when it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reasons of fraud or any willful misstatement or suppression of facts to evade tax. He therefore submits that for the period from as the assessment year pertains to the period, tax period pertains to the period from July 2017 to March 2018, the notice ought to have been issued in terms which within on or before 31st of March 2021. Full stop. However, in the instant case, the notice was issued on 27, when? Notice was issued on 27/9/2023, and as such, barred by limitation. He further submitted that as per his instructions, there has been no notifications issued in terms with section 168A of the AGST Act 2017 and the notification number 9/2023, which have been issued by the Central Board of Taxes, could not have been imported, could not have been applied by the state authorities by virtue of section 11(4) of the AGST Act 2017. পিছত হেতু contention তাৰ তলত সেইখিনি লিখি দিব হা দুইটাতে একে হ'ব এইটোতো একে হ'ব 21 huh? Because 21 I am taking that other series. I hope it comes before me. Deeply. Still beginning. Where is the petitioner?
Lord, I am the applicant and my respected senior is the petitioner.
What is the case about?
Lord, the case about they have challenged the approval order by which, my lord, SGM oblique election is already over. Approval had also been given, my lord, but that approval has been stayed by this honorable court, my lord. And now we are.
What approval?
My lord, approval to the SGM oblique election of a cooperative society, my lord, under the Cooperative Societies Act has already been over, my lord. And the approval to that SGM oblique election had also been accorded. Now, my lord, they, after the SGM oblique election and after the approval had been accorded, they have come and challenged the election as well as the approval order, my lord. And this honorable court was pleased to stay the same, my lord.
Now who is running it?
As per my instruction, my lord, one-man committee is running, my lord. And a democratically elected has been debarred, my lord.
Did they file an appeal?
No, my lord, they are required to file an appeal. They are agreed, my lord.
Yes.
My lord, they have not
Yes,
filed.
Mr. Talukdar.
Private party, Malik.
We'll hear him. First, you are the main person who have caused the problem. Here is a case where the election have happened.
Yes.
AGM happened. anybody is aggrieved, he can very well file an appeal before the registrar. But on the other hand, what he has done, he has challenged the AGM and the approval being the approval being granted without challenging the AGM. In this case, they have challenged the AGM.
My lord, if your lordship comes to WPC 3499.
Ah, before the matter.
899.
Yes.
Yes, my lord, the order, the impugn order, your lordship will find at page 91. This is the order put to challenge, my lord. And in this case, my lord, the honorable court has granted some stay order. To this order, this honorable court has passed an interim order, and that is why the applicants, my lord, are presently debarred from, my lord, run the office, my lord.
The petitioner has submitted that there were anomalies in the voters list in the election was to be held in 2 days. Constituency. Accordingly, the High Court passed an order not inclined to stay the election of the days of remand, that is, according the election of the register, that is the petitioner. Now, why is he challenged? Who are these people?
My lord,
Yes, who are you? Yes, Mr. Bhuya.
There's
You
the main
kindly-
crux of the
you
matter.
kindly come this side. Let us finish this
Yes,
small
sir.
matter.
yes, my lord.
Why should this stay vacating and all this thing?
Yes, they have to go to the.
Yeah. No, stay vacating is, if I touch out there, it will have an impact on this. So what is the? Now tell me, who are you?
My lord. We are the shareholders of the corporate society. The basic issue in this case is, my lord, when there is a vote in any corporate society or anywhere, my lord, maybe ML election, MP election, there is a voter list. Now the persons who are entering the voter list, they come and cast the vote. So incorporation of the names in the voter list, there are certain procedures. This is what I'll show to your lordship, my lord. What they have done, whether they have followed the section of Corporate Society Act and the rules. Very simple manner that way. If lordship is convinced, I've got a case. If lordship is not convinced, I'm out. I'll show to lordship.
No, understood. But did you challenge the elections?
My lord, this impugn order kindly, it has started from
No, I'm not on that. Did you challenge the elections?
election, not that way, my lord, but the
Why should we go into all this? You have a particular rule by which the election is to be challenged. Why haven't you challenged? You don't challenge the election, nothing, or file an appeal against the AGM or whatever may be. You come directly to this court. Why
no,
should this
appeal,
court?
appeal, that one has been dismissed by the rejected by the Register of the Corporate Society.
Where?
Page number 91.
That is what
That's what. He has rejected that one, my lord.
rejected.
Yes. And
You-
there I'll show, my lord.
No, this person concerned, he has withdrawn Akash Uddin.
My lord, that's what, my lord. Yes, this is the fact there, my lord. And the page number 91, second paragraph, kindly have a look, my lord.
I've read it. Tell me.
No petition was received between 11/5/23 to 13/5/23. It is not correct. Page 83 is his application. What? He is a person. He is a shareholder. He filed an application. My lord, kindly see page number 83. His application.
Now, who is
Page
the
83,
petitioner?
Annexure F. Annexure F.
Who is the petitioner?
Now, he was the person, Aklasuddin, he's also one of the shareholders, my lord.
Understood.
Yes.
Why he has not come before this court? Somebody else have come?
Yes, all along he was with us.
Then?
He knew very well, my lord.
Then why didn't you go there?
No,
and
no,
file
we have
it?
gone there. Next page, kindly see, my lord. It's there. We have gone there, my lord.
Who?
We, the
When?
petitioners. Page number 85.
When did you go?
We have gone on 13/5/23.
Then?
Kindly see page number 85.
Ah.
This plea you have taken, defective voter list, my lord. The rule, the act provides the living persons, in the name of living persons, you cannot become a voter, my lord. The act, section 55, very specifically provides that, my lord, and the rules. Now the persons, living persons in their name, my lord, they have come. That also by erasing the names.
You approach.
My lord, these are the members.
Why your application is not being taken?
That's what Lordship, kindly see the page number 91. I just
Sir,
write
page 85.
page 85, my
We
lord.
are concerned with 85.
Yes.
Because Akasuddin, I am not going to look into. He is not a party here.
Yes,
We are concerned with 85, 86.
85, 86.
Now, did you file this?
My lord, my colleagues, my lord, Shambhu Vaishnav, petitioner is Shambhu Vaishnav here.
Hmm.
The petitioner is here, seal number 4, in page number 86. He is there, my lord.
Yeah.
So he filed this one, my lord.
Then what happened to
But,
this?
kindly see, this part was not taken by this impugned order, page number 91. Second paragraph says, on 17/5/23, Akasuddin petitioner, what he did, my lord, he was along with us. He said there is a lot of illegalities, page 85, 83, lordship has seen, my lord.
No, understood. You did not submit on from 11/5 to 13/5.
No,
You
that
first
I didn't fight.
Huh?
Because Akasuddin was with us, my lord. So all
Understood.
persons fight.
Forget about that. Akasuddin is gone. But you have submitted on 15/5.
Yes,
Then 15/5 is beyond time. 3 days, isn't it, Mr. Talukdar?
yes.
3 days.
Yes,
Yeah.
85, my lord.
You went on later on. You put your date on 13/5, but you didn't give. You gave it on at 11:40 on 15/5.
That was received on 15/5 there. We filed it, but they show the receipt like that, my lord. 13/5.
So what? That is it.
But my lord,
Tomorrow you are going to file an election petition. I'm told Mr. Nath is one of the most
no, my lord.
Great
30 minutes is
lawyers.
expert.
great
No.
lawyers in election matters.
No, my lord.
You have been fighting tooth and nail on keeping that 45 days of presentation of the petition at the sanctity of that aspect. And now today you are not following that.
Now, my lord, here also this honorable court has directed, my lord, to look into this matter by this.
This court cannot go over the rules. The rules categorically mandates that you are to submit within 3 days. The court said that, okay, you go ahead. And then they may file any petition out there. And if they file, prior to the decision made under the 27, don't publish it. That's all. Nothing more than that.
According to you, I missed the bus.
You miss the bus. Matter ends there.
My lord, at least lordship can direct, my lord, because
I am not here to direct anybody. I am here to, whatever may be, you say, Mr. Nato, whatever may be, when there is a properly elected body, the elected body, with due respect, you can't state. It has far-reaching consequences. You may make the election subject to outcome of a repetition. To give a stay, has to understand that it is the wisdom of the voters, whoever has appeared out there. You missed the bus, you did not. Akasuddin is not before this court.
Akasuddin has teased us, my lord, in the last moment. I don't know what prompted and what lured him.
We dismiss the petition. What is the other petition for?
Same prayer, my lord.
Who is the other petitioner? There is
Hariprasad-
two petitions.
Hariprasad-
Hariprasad Das.
Hariprasad.
He is also the same footing.
No, I'm not there in the case.
No, whoever it is, he is on the same footing.
Same body.
Who is appearing for Hariprasad Das?
Lord, some other council was there.
Mr. Manik was there.
Manik was representing. my lord.
Chalo.
In this case, in fact, stay had been vacated, my lord. In the Hariprada, there is also.
No, we dispose it of.
Mal- mal-
That matter is there. Where is Mr. Banik? He's not there. Matter has come up in the list. His
Yes.
name has been shown.
Shown, name shown, me.
Okay, fine. Hey, cooperative society.
Taken in the ground, otherwise, my lord, this petition of this such a very good case. Because the rule provides, my lord, the living persons, you cannot replace them. What they've done, we are still alive, some persons, and all of them entered their name in the vote of list and they cast the vote. Textually inside, my lord, it's a very good.
এই এখন রুলস থাকা এখন আছে সেইটো আপনার লই না আমার এখন নতুন এখন লবছুন
The same secretary.
Heard Mr. M. Nath, the learned counsel appearing on behalf of the petitioner in WPC number, petitioner in WPC number 3499/2023. First, none appears on behalf of the petitioner in WPC number 2817/2023. Mr. A.R. Bhuya appears on behalf of Mr. S.K. Talukdar appears on behalf of the respondent numbers appears on behalf of the Corporation Department and its officials. Mr. A.R. Bhuya appears on behalf of the private respondents.
Private respondent number 13, my lord.
Only one.
Fine.
What about the others?
Not-
I'm appearing for the secretary.
Appears on behalf of the private respondent, namely Sri Saurabh Das. And Mr. J.M.A. Chaudhary appears on behalf of one of the or appears on behalf of the secretary of the Gandhigram Cooperative Society. The instant writ petition came up today for consideration of an interlocutory application filed for vacating and or staying for vacating Mr. Bonik, you are there. You want to be represented or nothing?
Sorry.
No, you want or nothing? Okay, as Bonik Didibo, you don't none appears for this.
Catch up which is great, man.
It's okay. The instant writ petition, the instant writ proceedings came up before this court for consideration of an application seeking vacation, modification and alteration of the order dated 19/6/2023, passed in WPC number 3499/2023, wherein this court, as an interim measure, directed had stayed the approval of the proceedings of the AGM for the year 2023-24, including the formation of the Board of Directors of the Gandhigram Cooperative Society Limited for the term 2023-24 to 2728. Taking into account that any decision rendered in the instant in the interlocutory application would be deciding on the merits of the instant writ petition, this court, with the consent of all the parties to the instant proceeding, all the counsels appearing on behalf of the parties to the instant proceedings, have taken up both the writ petitions for disposal at this stage. From the materials on record, it is seen that the society in question is in the name and style of Gandhigram Samabhai Samiti Limited, which is registered under the Assam Cooperative Societies Act 1948, bearing registration number K-19 dated 10/9/1973. The president and the erstwhile president and the secretary of the said society of Gandhigram Samabhai Samiti Limited, hereinafter referred to as the society, had issued a notice on, what is the date?
25/4/2023, my lord. It pays
25/4/2023.
Page 36 of my IN.
No. It must be prior to that. 25/4/2023, intimating all concerned that on the basis of the decision taken by the executive committee of the said society, the election of the board of the directors of the society for the period 2023-2028 would be held on 10/5/2023 between 9 a.m. to 12 noon at the Netaji High School, to be followed by polling between 12 noon to 4 p.m. Full stop. Pursuant to the said notice, some of the shareholders being aggrieved in the manner in which the voters list was prepared. And one shareholder being aggrieved by the manner in which the voters list was prepared had approached this court by filing a writ petition being WPC number 24939/2023. Full stop. This court, upon hearing the learned counsels, via an order dated 8/5/2023, disposed of the said writ petition. Holding inter alia that as the election was to be held in 2 days' time, the question of stay of the election to be held under the aegis of the election authority, that is the registrar or his representative, did not arise. This court further observed that the election to the board of directors of the society be held on 10/5/2023. However, the registrar, that is the register of the cooperative society, along with the the Eastern Register was directed not to give any approval to the election oblique the AGM to be held on 10/5/2023 prior to deciding the grievance of the petitioner in terms with Rule 27 of the Assam Cooperative Societies Election Rules 2019, for short, the rules of 2019. The petitioner in the said proceedings was directed to submit a representation along with the writ petition with regard to his grievance before the Register of Cooperative Societies between 11/5/2023 and 13/5/2023. It is, however, very pertinent to mention that the petitioner in both the writ petitions, which are presently being adjudicated, did not question the challenge, challenge the election to be held, did not challenge the notice dated 25/4/2023, whereby the elections were notified to be held. They were also not a part of the writ petition being WPC number 2439/2023. It is seen that pursuant thereto, the elections were duly conducted and the results were also announced on when? Results announced?
Results announced on Milot, 40, page number 40. 40.
Huh?
40 Milot of the repetition Milot. No, not of the IA Milot.
When was the
Milot.
results announced? On that day itself?
29th of May 2023.
Huh?
29/05/2023 Milot.
That was an approval. That is an approval. That is not the results announced. Result was announced on that day.
Same day it was declared. Milot, on the same day it was declared and approval was also given Milot, for our instruction Milot.
When was the results announced? You are the secretary.
Just today I entered APR.
Yes. Mr. Nath, do you have any idea?
Same day, probably these are small. Same day it is being done.
On 10.
Approval is statement.
Approval is different, but the results were announced on 10/5.
Same day.
It has further been submitted that the results were announced on 10/5/2023 itself. It is further seen that the petitioner in WPC number 2439/2023, thereupon on 12/5/2023 had submitted a representation. However, the said petitioner withdrew the said representation. as would be seen from a perusal of the order dated 26/5/2023 itself. It is further seen that the petitioner in both the writ petitions, that is WPC number 2817 of 2023 and 3499 of 2023, have, along with six others, had submitted another representation on which was received by the senior assistant on 15/5/2023 at 11:40 a.m. Pursuant to this representation, however, was not taken into consideration by the respondent by the Register of Cooperative Society in its impugned order dated 26/5/2023. And the AGM of the society in question held on 10/5/2023 was approved. Being aggrieved, both the writ petitions were filed challenging the order dated 26/5/2023. This court heard the learned counsels appearing on behalf of the petitioners and have given their anxious considerations to their respective submissions. From the perusal of the materials on record, it is clear that the petitioner in WPC number 2349 2439 of 2023 is not before this court. Challenging the impugned order by which his petition was rejected. His petition was held to be withdrawn. It is also very pertinent to take note of that the elections of a cooperative society can be challenged as per the Assam Cooperative Society's Election Rules 2019. Rule 27 of the said rules, being very relevant, is reproduced hereunder. A perusal of the above rules categorically shows that any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the results before the election authority. It is an admitted fact that on 10/5/2023 itself, the elections were declared. And as such, any person who is aggrieved has to challenge the said elections within the period of 3 days from the date of declaration of the results. That is on or before 13/5/2023. It is seen that none of these petitioners have submitted any election petition or representation within the stipulated period. Rather, the petitioners herein have submitted a representation on 15/5/2023, has submitted a representation which was only received on 15/5/2023. Taking into account that the State Assam Cooperative Society's election rules, taking into account that the rules of 2019 categorically deal with the manner in which an election dispute is to be challenged. And there being no challenge to the state provision. In the opinion of this court, the Register of Cooperative Society was justified in approving the election which was held, the AGM which was held of the society on 10/5/2023. By the impugned order dated 26/5/2023. Accordingly, this court finding no merit in both the petitions, the same stands dismissed. Interim orders, if any, stands vacated.
One correction probably, my lord.
Yes, please.
In the notice, my lord, the counting lordship is asked, my lord, it is written here. Counting of votes shall start at 10 AM on 12/5/23 in the temporary license. So lordship, that may be little.
Hmm?
Declaration result. Counting is the 12/5/23, it says, the notice says. Election held on 10/5. In the notice, it is written, counting of votes shall start at 10 AM on 12/5/23. Just a little correction probably. Page number 37. Serial number 9. Petition, first petition. Serial 9.
Where?
Page 37, serial number 9. Counting of votes shall start 10 AM on 12/5/20.
Where's serial number 9?
Bottom.
Page 30?
7. This petition, my lord, my petition, first petition. My lord, 3499.
Read the Bengali portion
My lord.
at 9.
Yes. ভোট গণনা আগামী 12/5/23 তারিখে রোজ শুক্রবার 10 কোটি হইতে my lord, that's all.
Committee. So the committee will be formed only this.
Now this is ভোট গণনা, counting of votes.
No, no, no.
Yeah.
After this, what does it say? Bhut Gonona Purbe. Purbe. Means after.
No, porbo, the, my lord, that
Schedule.
Milord, it is like, Milord, the,
porbo is not purbe,
Milord, the vote Gonona itself
Yeah,
will be.
the subject of that counting.
scheduled.
So when was the election announced then?
Milord, on the same day itself, on 12, the as per Milord, the Bengali version, vote Gonona Porbo, Agami 12/5/2000 Engraji.
So then their application has to be considered.
No, Milord,
It is within 3 days.
it is on 12/5, Milord.
If it is on 12/5, then his application has to be considered.
No, it is, his applications, Milord, is on 15/5, Milord.
So that's 3 days from the date of declaration of the results. If the Bhut Gonana was on 12/5, then his application is in 3 days.
12, 13, 14.
Shall starts at 10 AM of 12/5/2023 in the temporary block.
Yes.
So it will be 3 days.
15th comes 3 days.
So it will be within time. Then we set aside this order and then direct them to decide that application if it is within time. Because he cannot decide. It's a different thing. Akasuddin was given a time by this court, but then also 27 is there. So 27 days is the mandate out there, the first portion of it. So they have filed it within 27. So under such circumstances, if it is 12, 5, then he has, his application was received within time.
Says my lord, yes, my lord, it as per.
Then his application has to be considered. Without doing it, why did the authority give the approval? What do you say, Mr. Naluka? Rightly or wrongly, on that day, it has been received 15/5. If it is received on 15/5, then it is within time. So then they has to decide the dispute. They let them decide the dispute and then decide.
Can my learned senior friend can obtain an instruction that whether this has been acknowledged by the authority or not? It is this.
You find out that
15/5 million.
all this while this has happened. Nobody has denied why the matter has been pending. That is why I specifically asked both of you, what is the date of the result? You are saying on 10. Get your instruction, 2 o'clock. I'll make the correction. The last portion of it, huh? The last one, can you my I'll make it, set aside this and direct them to decide their application and thereupon decide as regards the year. Otherwise, making it doesn't make sense. That is why I specifically asked you, you said no. Dispose of it, खाली ये तो ठीक हो.
Instruction to annual, no, I send electors. So, my lord, therefore, there was no occasion to held the election on the day of the SDM, which was held on 10/5. My lord, we have the BOD has been declared to be elected, my lord.
10/5 itself.
10/5, and therefore, my lord, in application of the rule 13 sub rule 1, this can be done, my lord, of the election rules, my lord. That's why, my lord, it has also been recorded in the approval order also, my lord.
Sixteen posts of directors. Posts,
15, my lord. 1/5.
there were 15.
15, my lord.
15
And,
nominations.
yes, my lord, and at page 40 to 41. is
15
the list.
nomination to the 15. You say it to be the post of directors or what?
Directors, my lord. All are being before, my lord.
15 post of directors.
Fine.
Who are the private respondents who have been declared?
Lord, along with me.
6-2.
6-2, my lord. Lord, it starts from 7.
Who were the private director? Who were the private
Yes, yes,
respondents?
private directors, my lord, may be pleased to verify from page 40 of my IA, my lord. Page, huh? Huh? Or I, not executive. I. Page 40, my lord, Sri Shillong Khalsa, Srimati Shukla Sinha, Sri Anjali Mishra, Sri Ratish Chandra Dev, Fazlul Haq.
No, these are private respondents.
My lord, in this petition they have made, my lord.
As Shukla Sinha,
My lord. Yes, is there, my lord. 8 to 23. 8 to 23 is the private respondents.
8 to 22, 23.
Ekhlasuddin is not here, my lord.
8 to
huh?
8 to 20.
8 to 22, my lord. From respondent number 8 to
Who
20.
is 23?
23 is
Oh, that
Ekhlasuddin, my
person.
lord, that person who filed the
8
earlier.
to 22.
My lord.
Order number 8 to 15, the writ petition.
Huh?
8 to 15 in the writ petition.
15. No, it can't be 7. It has to be 15.
8 to 22, my lord. We are verifying the name, my lord. Shukla Sinha.
1, 5, 6, 9, 14, 22, sorry, after 22.
The order remains the same.
22.
My lord.
There's a, my lord, one thing, that section 13, how should have seen, my lord, now? That declaration on the same day. But to my information, my lord, there is no declaration they have made on that day. They have not made any declaration. They have not made that. And on 25-23, the secretary has written to the assistant registrar, just now I got the information. I just. It was on communication, peculiar communication.
Is our assessment with the main.
On 25-23, he writes.
Will apply, no?
These are no relevance. Because anyways, why did you then challenge prior to that? Order remains as.
Obliged, my lord. Highly obliged.
Upgraded item number 46.
Yes, where is the forest? Did you inform the forest? And then, how can I help you? You should have informed. When I didn't fix it at 2 o'clock, I gave you the liberty to mention Means you ought to have informed the forest. Wait for your turn. Well, Yes, madam, anything?
No, my lord, instruction is awaited on our part. Give us some.
I think he must have got it. That is why he's
Maybe,
not
my lord,
bothered.
I have file of.
None appears on behalf of the petition on
Last
call.
occasion also he has.
On the earlier occasion also, the petitioner had not been represented. Taking into account the above, it seems that the petitioner have lost interest in the instant proceedings, for which the instant petition stands dismissed for non-prosecution.
Okay, the madam, not, I don't want to press this matter.
Huh?
The petitioner has, shot dead, your lordship. Petitioner shot dead in last month, your lordship.
Shot dead. Then,
Not on part.
what is your case?
Regarding the, election of the police, your lordship. Take of my property, your lordship.
Petitioner is dead. Mr. The learned counsel, Mr.
Yes, Roy.
S. Roy, the learned counsel appearing on behalf of the petitioner submits that the petitioner had is that last month the petitioner had expired. This court, upon taking into account the reliefs which have been sought for, and they being personal to the petitioner, the instant nothing survives in the instant writ petition. Accordingly, the instant petition stands closed. Yes.
This matter, we have taken steps on Friday, last Friday.
Okay, now tell me, what is your case?
In this case, I am claiming, the petitioner was asked to do some work under the Borle University. In pendency of that work, the work was assigned to some other person by NIT.
You are entitled to certain money. You have taken steps against whom?
Yes, all. Number
Last
one,
week,
last week, Friday.
Mr. Arshama. Arshama.
Yes.
The learned counsel appearing on behalf of the petitioner submits that any instructions?
No, Lordship only recently, last week they served us steps, extra copy, Lordship, and I have sent it to the authority.
Means that he has taken steps only recently. Taking into account the above, list the matter again on 2nd of December 2024. In the meantime, the respondents are given the liberty to file their, bring on record their stand by filing their affidavit on or before 28th of November.
13.
Mr. D. Gogoi, wait, that matter. Where is Mr. M.A.
Could I file this?
The issue is very interesting.
Yes.
The petitioner said.
Where is he? Now he is no more.
Yes.
One person is there, one person is
Yesterday they
not.
informed me.
Okay, we'll take it up at 3. You come
Well,
at 3 o'clock and ask the. Yes, what is this IA?
IA has been filed, but I have found, my lord, some typographical mistake in respond number, that is newly included respond number 3, my lord. The deputy commissioner, district commissioner Yadav Tegu is not there, my lord. Only Ankur Bharali is there. So, my lord, probably
What? How can you file an IA for what?
implement, my lord.
Impletement, you can't implead anybody in a contempt matter unless you inform them.
Yes, I have already informed, my lord. So
Where?
I'm not pressing at this moment, my lord, because I have to correct this person's, my lord. I have informed, my lord, that
What is your directions? What is your case? Let us see. Contempt matters. Accordingly, the states are directed to pay the compensation to the petitioner at the present market rate, which shall be done in accordance with the prevailing custom rule. This is it. Page 15. That's the order. You are seeking compensation. For what?
my lord, land was taken by the this respondents, my lord.
How can
Without acquiring any land, without acquisition, my lord, without following any procedure, my lord.
then what has happened?
My lord, this eight biggest land, my lord, patta land, my lord. It was taken by the authority concerned.
Then who is appearing?
My lord, I appear for respondent number 3, my lord, in the contempt case, in the main case, my lord.
So all this.
Return back the land. Return back the land. You cannot.
My lord, the acquiring difference, I am for the deputy commissioner, my lord.
You are the deputy commissioner. You are the main cause of problem. You have taken the land. Nobody has the authority to take the land. Have you acquired?
My lord.
You have acquired. Who?
My lord, I'll have to file affidavit because at that
Why do
time,
you have to file affidavit? Have you acquired or not? This is a simple question. If you have acquired, there will be a notification.
definitely, my lord. At
You
that
have
time-
it with you.
At that point of time, my lord, I was not a deputy commissioner, I was.
Forget about deputy commissioner, this or that way. I'm not concerned. I'm concerned with the post of the deputy commissioner.
Let me file affidavit, my lord.
There is an order passed by this court wherein it categorically holds that the petitioner is entitled to compensation for the 8 bighas of land which you have taken,
My lord.
whether you have taken or not.
Now, my
If
lord,
you
my
have
lord,
taken, you have to either return it or pay compensation.
My lord,
And
the-
along with
already-
that, requisition expenses.
Already the proposal has gone, my lord.
What? You cannot have this land for this. Taken the land for what?
For establishing one mini health center, my lord.
Mini health center. Cannot. Somebody else land, how can you take it?
The compensation has to be paid, my lord.
Then
That health department will respond. my lord.
health. Where is the health? Health you have made party.
Yes.
Earlier he was a health.
This earlier party, my lord, they have been already transferred, my lord. So now new persons have been included, my lord.
Notice has to go, my lord.
Where is the health council? You are for a deputy commissioner
My lord.
on a personal capacity. Are you a counsel for the government or what?
Or personal capacity. I filed
Personal
my-
government. Yes, government, any government counsel? Yes, Mr. H. Sharma. Yes, come in. Get instructions in this matter. How a land of a person being taken, you have not paid compensation in spite of an order being passed by the court.
Item 13, Lordship.
Yes.
Copy of the given order then.
The Let us see your donation. Why you are not filing review or anything against this order? On one hand, he is asking, he says he has donated the land in lieu of getting 2 appointments. And now the court has passed an order that you have to pay the compensation. If he has donated the land, where is the question of getting any compensation? Tell me.
Not donated.
Huh?
It is not donated.
Your case only, it is being recorded in this order.
Donated, my lord. It was,
In the year 1995, Amguri Mini area was destroyed due to where thereafter on a resolution taken by the public to have a iman, the petitioner donated a plot of land measuring 8 bighas in the year 2001.
donated,
This is what has been recorded.
not donated.
And as you have not got a job, that is why you have sought for various relief.
No, my lord, it is not donated
And the
it is-
petitioner too was engaged at a monthly wage by the hospital and so and so. Then why the state is not filing an appeal against this order? There is a donation being made. Where is the question of petitioner being entitled under 300A? It is only when a land has been taken without the due process. Now he has himself donated. This is his case in his petition. This is the order. Okay, Mr. Pegu, you do one thing. You file your affidavit.
My lord.
Better off. Mr. G. Pegu, the learned counsel appearing on behalf of the respondent number 3 submits that he may be given 3 weeks' time for filing an affidavit. So taking into account the above, this court grants 3 weeks' time for filing the affidavit. List the matter again on 9/29/2024. In the meantime, the affidavit will be filed. I not pressed. Mr. B. Chetri, the learned counsel submits that there are for certain formal defects in the interlocutory application for which he would not like to press. He however submits that he may be given the liberty to refile by removing those formal defects. Accordingly, the I stands closed on withdrawal. However, liberty is given to the petitioner to file after removing those formal defects. You are paying for whom?
0.5, Lordship, Health Department.
Oh, yes. What is this land being taken over without paying compensation?
Lordship, the proposal, we were supposed to send a proposal, but I believe the court would be best assisted by Counsel B. Lordship. He's on legs, Lordship. Proper instructions are with him, Lordship. Don't have the proper instructions for this, Lordship.
So you are not appearing.
No, Lord.
None appears on behalf of none appears on behalf of the respondent number 4 and 5 on call. Also, it is also noticed that no affidavit has been filed by the said respondents. It is further directed that if the said respondents do not file the affidavit, this court would be constrained to pass appropriate orders seeking personal appearance of those respondents.
Please, my lord. My lord, also give an updated instruction as to the status of acquisition amount.
Take it away at 3 o'clock. আগৰ অৰ্ডাৰটো ওপৰতে লিখি দিব দেই।
Well, this is application for winding up under the 1956 Act.
Then
Perhaps it has to be transferred to NCIP. Perhaps not, it needs to be transferred to NCIP.
is it transferred?
Correct.
Can't transfer because that provision has not been notified. Then
Lord,
argue.
yes.
Let us dismiss your petition.
Well, earlier this notification was issued and well, they appeared. Then, my lord, they filed an application that the matter was pending for the JFR, my lord. So the further proceeding was stayed. my lord.
Then,
So after my lord, 2016, I think this Sikh Industrial Company Special Provision Act has been my lord repealed. So now that BIFR proceeding stand abated.
then what is the reply?
They reply, my lord, they say that that the company was
Has any checks been honored? Has any of those checks which were mentioned in your notice been honored?
no, my lord. Actually, they did not deposit money.
Huh?
They did not deposit the check.
Who?
Actually,
Then why didn't you deposit?
because my lord, they were told that they'll make the payments and in the meantime, perhaps the checks are. Okay.
Why didn't you deposit? You say that it has been dishonored at page 16. This is your notice. You have not read it properly.
Yes, sorry. I'm not, my lord, I'm not going to write. I was under the impression of the test to be transferred.
What? Take fresh steps. It seemed that the respondent, the instant writ petition came up before this court after it came up before this court. No. Also, taking into account the petitioner is only represented, however, not the respondents. This court directs the petitioner to take fresh steps upon the respondent by way of registered as well as usual. List the matter again on.
Sir, Kakuti was appearing on earlier occasion, Mr.
Her name has been deleted, Usha Borua.
No, my lord, Miss M. Kakuti was there.
Anyways, take steps. List the matter again on 25th, by registered here within 7 days. List the matter again on 25th of September 2024.
I beg to apologize, Lordship. The item number 13, which was being recorded, I was under the wrongful impression that item 54 was going on, Lordship. The health department's name has also not been reflected in the cause list. We were not able to identify it properly, Lordship.
The order has been passed. I can't help you.
Auction list item number 1.
Clear it. Work permission issue. Yes, what is this?
Also kindly have the notice dated 31st July 2024, Your Lordship. It is at case number 208.
Where is the notice?
208 and typed copy 195. It begins with
208.
195. 195.
Yes,
Right. May I
tell
read-
me.
may I read your lordship?
Hmm. Yes, tell me.
My lord. Thereafter, your lordship kindly have page number 200. Along with this, they have served the copy of the order dated 31st January 2024. After 6 months, and they have stated that according to the order dated 13th March 2023, they have given us the opportunity of hearing. Your lordship kindly have page number.
No. We are concerned, you are challenging page 208.
Page 208. First, they have served, and thereafter, they have given on 1st August 2024.
Madam, what are you challenging before this court?
Court, your lordship, 31st July 2024. Along with your lordship, 31st January 2024, because they have stated that it is an speaking order, your lordship.
Madam, you have only challenged
Both, your
here
lordship.
31.
Because it is the notice, and I have also given the reply, your lordship. The relevant part of
Is to see the effect of the operation.
31st January 2024 is same, your lordship, 204. In similar case,
So what is the order of 31/7?
31/7, your lordship, kindly have 204.
208? Yes, what is it?
In
Yes,
view
what
of
is
the above discussion, I am of the considered opinion that all licensees whose licenses have been expired long back have to vacate the stalls at earliest with a suitable notice period of 15 days by 15th February 2024. However, the aforementioned licensees are directed to pay the enhanced license fee within 15 days from this order, failing which railway reserve the right to take legal steps in realizing the due arrears license fee from the above mentioned licensees. Upon the payment of license fee by the above mentioned licensees, there will be eligible to participate in fresh tenders, e-auction floated by Lumding Division in future, and will also count their catering experience, which is one of the mandatory eligibility criteria for getting catering units license from the railways, your lordship. And in this, your lordship, they have stated 203 that no license fee have been deposited by them to the railway till 31st January 2024, while your lordship petitioners have deposited all the license fees. I have given them notice, your lordship. Kindly have the notice along with the license fee. It is a bundle of, because they are 188 members, your lordship. And your lordship, they have also given, kindly have page number 194, relevant part from their side, your lordship, 14th June 2023. License of opportunity of hearing fixed on 30th June 2023 to be given appellants in compliance of order dated 13th March 2023 passed by Honorable Guwahati High Court in writ appeal number 47/2023, 54/2023. In compliance of the order dated 13th March 2023 passed by Honorable High Court, writ appeal so and so, opportunity of hearing to use scheduled time, date, venue, and said hearing are as follows. Only within 5 hours, your lordship, they have given the opportunity of hearing to 188 members, and they have called them and put their signature and said, okay, go and your license will be renewed. Only they have verbally stated. Your lordship, kindly have the affidavit of all the petitioners. Next day, your lordship, page 72, it begins with page 22 to onwards, your lordship. Your lordship. Carried, your lordship. One more. Entire one of the affidavit. Page 233, one of them. Request for providing an opportunity of hearing in accordance with principles of natural justice as well as justice, equity and good conscience with regard to consider the claim of renewal of license as well as providing the format of affidavit circular number 22 of 2027 as provided the Honorable Supreme Court order, your lordship, for the livelihood that one person is got the one kiosk or one shop, that their shop should be renewed on the basis of the license fees, your lordship. What happened in all the division, the format of circular number 22 to 17 has been supplied except the lumbering division, and the petitioners always made them request. Ultimately, when the notice has been given in the large numbers, your lordship, they have given the reply on 31st, 2024, your lordship. Railway station in view of so and so, deponent licensee so and so, the deponent declare he has applied renewal before the office concerned for that implementation renewal application so and so, writ appeal number 4754 before this Honorable High Court. The Honorable High Court was pleased to pass an order 13th March 2023. 14th June 2023 issued by your office, the deponent attending personally with all documents on 30th June 2023. The deponent appeared before your office along with all the documents as demanded by you. The letter dated 14th June 2000, but only signature was taken in register by your office concerned on 30th June and also received all the documents. There was neither hearing took place nor any opportunity has been provided to the deponent with regard to put her grievance of not allowing to deposit license fee. The deponent is mentioning here about the steps of the Railway Authority who has fixed schedule time, date, venue, 30th June for only 5 hours in Chamber of Senior Divisional Commercial Manager, Lumbering Division for hearing the matter of 188 licenses, which is apparently appears an error at the face of record that for the extent of hearing of 188 licenses, there was no spacious place to sit the licenses and only within 300 minutes, the Railway authorities had completed all the hearings. It is false and it was never provided any opportunity of hearing to the deponent on 30th June 2023. The deponent has always tried to know about the consequence of letter dated 14/2023 and its meeting dated 30th June 2023 of receiving signature and document, but it was always concealed by your office concerned personnel. There is no result order at the meeting dated 30th June 2023. That the deponent has already served the notice on 20th July 2000.
Yes, Mr. B. Sharma.
Basically, this petition arises out of the judgment rendered by lordships in one of the cases, my lord. I've made a compilation of the judgments, my lord.
It is there, I've seen it.
They have approached the Supreme Court also. They did not get a favorable result out there, my lord. And suppressing that fact, my lord, this petition has been filed. Also, my
didn't
lord.
suppress. The order dated
Again,
13th
they-
March.
No,
has been
no,
com-
Supreme Court order is here.
No, the latest one, probably they have not.
That is not, your lordship.
Yes.
That is.
Against they have filed a review application against the division bench order, my
That
lord.
was returned back here, your
That,
lordship.
that was dismissed. The division bench held that renewal is not permissible. Against that, they have opposed the Honorable Apex Court, my lord, that decision, that order, that SLP has not been admitted, my lord.
That's there,
And
the
page
Honorable Court
25.
said that the order dated
25, my
13th
lord.
March 2023 is
Page 25
absolute. There
of
is
the
no need
compilation.
to review that order. Only the Honorable Supreme Court has stated there and nothing more than that. And in pursuance of thereafter, your lordship, in pursuance of the order dated 13th March of 2023, they have stated that they are going to give the opportunity of hearings. After the returning from the Supreme Court, your lordship, the railway has
Yes,
given.
the hearing was given, my lord.
And only within 5 hours, they have given the hearing
Not
of
at all.
opportunity
Basically,
to
the
the
writ petition-
188 members. They have given the signature. They have taken on their record and also received all the documents and verbally assured that renewal is going on, subject to decision of the High Court, subject to decision of so and so.
Suppressing this material fact they
how
have
it
approached,
was
my
your
lord.
lordship
This
within
asset
7
is
days.
still pending before the Honorable
And
Apex Court.
Still one point, they have given the notice. We have given the reply. They have to decide it either in against or in favor, and thereafter they have to proceed whatever they want, your lordships.
Definitely not. In terms of the Honorable Division Bench order, we have given the notice. They appeared,
The
the
notice,
hearing was conducted.
opportunity of
How many
hearing,
times will
how
will you give the
opportunity of
notices to them?
hearing is not in
It will
accordance
be
with
a
law.
never-ending process.
Opportunity of hearing is not in accordance with law, your
For
lordship.
the last 20 years, they have been continuing
And they
their
have
business
deposited
without a
all the
renewal.
license fees. They have issued the arrears of license fees of those persons who are no more, your lordship.
No, madam, on what basis are you now enjoying the stalls?
Because we are given
Forcefully,
the
ma'am.
license fees.
Huh?
We are regularly
No,
depositing.
no. No
Forcefully.
business of paying a regular license fee and all. What is your basis? There has to be a
Yes.
license being given to you. You
Yes.
cannot on the basis of this,
Your
nothing
lordship,
doing.
this is the basis because according to the order of Honorable Apex Court, 19th January 2016, we are the
19th January 2016 has gone for a 6 out there. Because of the fact that is 2016, thereupon they came up with this proposal. Because 2016 judgment came at a time when they had the catering policy of 2010. Now 2017 catering policy holds the field. Nothing doing.
Nahi, your lordship, for a moment. Once,
Nothing doing.
your lordship, because the opportunity, I only came here for the opportunity of hearing, your lordship.
There is no
And it
opportunity
is-
of hearing. There is no opportunity of hearing. Hearing has happened.
Oh, for a moment, your
No,
lordship.
nothing doing.
There is the legally.
How, on what basis? Tell me, can the GM as of now, GM is the highest of the Northeast frontier area, grant you an extension?
My lord.
No. Because of the policy of 2017, they cannot.
We are not governed by the 2017 policy. I have stated, your lordship. We are governed by the 2010 policy and it has been.
2010 policy at best would have allowed you for another 5 years, nothing more than that. No, I'm not.
The judgment, your lordship.
No, nothing doing.
If your lordship may please.
I'll just
for a
issue a,
moment.
no, nothing doing.
Keep
You
going.
want a notice, I can issue a notice, nothing more than that. You throw them out.
Your lordship, for a moment.
What the create-
Only my humble submission. Only my humble submission.
You should
For-
have done it the moment I passed the judgment. Why did you allow them to go to
We
the
we
division
vacated
bench?
the stalls, my lord. We vacated the stalls. Thereafter, they approached the division bench and after that, they forcefully opened all.
No,
the-
no, no, not forcefully. Without the
Yes, yes,
consent
yes,
of
yes.
railway, it is not possible, your lordship. Only my
Nothing
humble-
doing.
Thereafter,
my-
they went to
your
the
lordship,
This
apex.
is
for a
a case
moment.
of forceful, nothing.
Your lordship, only my humble submission.
No.
My reply is, your lordship.
No.
It is
My
reflected that
reply
they have
is pending
forcefully opened.
until the disposal, either they reject, your lordship.
What?
My reply is pending. Notice they have given. I have just given the reply. They either reject or accept. For that period, your lordship, they has not to interfere. Because there is the livelihood.
Absolutely, throw them out immediately. Throw them out.
Your lordship, for a moment. There is the livelihood, your lordship, for 188 member. Your lordship.
Nothing doing.
If lordship.
Throw them out immediately.
Yes, yes.
My lord. For a moment.
If lordship
Your lordship.
permits, I can give one more clarification. Now, she is stating that she is covered by the 2010 policy. That is also not a fact. Because their licenses came into existence prior to issuance of the 2010 policy.
Yes, yes.
That means they would be governed by the 2005 policy.
No, not at
If
all.
that be so,
When the
the
subsequent-
2005
Your lordship,
policy
when the-
doesn't
no, no.
provide for
Your
renewal, my
lordship,
lord.
for a moment, when the
Doesn't provide
subsequent,
for renewal
when
at
the
all.
subsequent policy.
Are you not taking steps for throwing
Yes,
them?
we have issued the notice on 15th we are vacating, man.
15th of?
This month.
Okay, we have this matter after 15. In the meantime, throw them out.
Your lordship, for a moment.
Independence Day,
Some, your
throw them
lordship,
out.
some restriction, your lordship. Only my humble submission.
No,
My, your
nothing.
lordship, my humble submission, for a
nothing.
moment.
I think this is the
Because
best
they are,
way.
lordship, opportunity of. They have
No,
got
you don't have a
opportunity of
case.
hearing. And for the notice, your
Nothing
lordship,
doing,
reply.
madam, nothing.
Your lordship, for a moment. My humble request, your lordship, only 7 days, your lordship may provide.
For what?
They have to decide the reply.
No, nothing doing. No
What
reply business. Reply, they have taken everything into account, nothing doing. There's the, no.
Decided.
You even went to the Supreme Court after that review, you withdrew and to file a review.
My lord.
Then again, when the review got dismissed, then you went again to the division bench.
That has been suppressed.
That's, no, then, no, then the question arose as to once you have withdrawn, can you again re-agitate the say respect to the matter?
13th March 2013 is the absolute order, your lordship. For that moment, in that aspect, your lordship, for a moment, एक बार आप पढ़ लीजिए, your lordship. Your lordship, if you agree, I don't.
No,
For a
nothing doing.
moment, only relevant part.
Nothing doing.
The court has held, division bench has held, your
No,
lordship,
nothing.
that the license fees will be paid.
And why these materials are so fat?
Because affidavit has been filed on the basis of opportunity of hearing from all the 188 members.
Very well.
Your Lordship.
Fine.
Your
That is
Lordship,
the problem when you give them to, they cannot do anything.
Lordship, for a moment,
Well,
opportunity of
should
hearing.
notice
Some observation may be given.
Nothing doing. Nothing doing. Issue notice making it returnable on. How much time? This should be dismissed.
It should be
No, Your
discussed
Lordship.
actually.
No, Your Lordship,
With
because
cost.
Your Lordship,
How many? 188.
Your Lordship.
188 into 1,000 less.
Your Lordship,
1
they are
lakh.
poor persons. They
1
are
lakh.
poor persons, Your Lordship.
You get good money on
They
that.
are poor
1
persons,
lakh
Your
per
Lordship.
person.
They are the poor persons, Your Lordship.
No poor persons. This is the type of litigation you are carrying on for long time. You under no circumstances can get.
Notice may be issued, Your Lordship. What they may evict, there is no problem. Notice may be issued.
No notice.
Further
Dismiss.
complicated finding.
No, dismiss
For
on the
our-
first day.
Lordship, for ourselves.
Absolutely, my lord.
For ourselves, we are,
For what?
yes, Your Lordship. For ourselves. Meaning thereby, Your Lordship, you understand. For ourselves. just for this.
Absolutely not, my lord. This
Yes,
will-
Your
this
Lordship.
may further complicate the issue.
Your Lordship.
This may further complicate.
No, I'll make it clear. The issuance of notice shall not bar the authorities to take action as per proposed. Make it very
Fine.
clear. Issue notice making it returnable by
6 weeks, my lord.
9th of September 2024. Mr. B. Sharma appears on behalf of the respondent numbers 1 to 7. Taking into account that all the respondents are duly represented, the extra copies of the writ petition be served upon them by Wednesday. Copies. The case of the petitioner herein is that the petitioners have been issued notices on 31/7/2024.
I have given on 1st August, Your Lordship. Page 165, Your Lordship. Annexure 27.
Whereby
Annexure 27.
the members of the petition association have been advised to vacate the catering stalls within 15 days, that is by 15/8/2024. In addition to that, the members of the petitioner association were also advised to clear all area enhanced license fee due as on 31/7/2024. Further to that, it was also directed that once such amounts is being cleared, the members of the petitioner association would be eligible to participate in the fresh tenders e-auctions floated by the Lamding division in future, and would also count their catering experience, which is one of our mandatory eligibility criteria for getting catering units license from the railways. The petitioners have challenged the impugned order on the basis that the petitioners have not been afforded a proper hearing in terms with the order passed by the division bench of this court and the order by which the division bench of this court. Footstep. And as such submitted that till this court have taken note of the materials on record as well as the order dated, notice dated 31/1/2024. From the speaking order, it is seen
The compilation I have provided the original speaking order, my lord.
that out of 188 licensees, only 88 persons who have licenses had appeared, of which 15 were valid licenses. It is also seen that 74 persons who were issued licenses were not alive, but were represented by some other people. 12 persons had neither any license nor anybody had appeared. This court further have taken note of that the division that pursuant to the order passed by this court, wherein the writ petition filed by the petitioner was dismissed, an appeal was preferred.
Help of that compilation, my compilation.
There was only a direction. And the order passed, the judgment passed by this court was only modified to the extent that an opportunity of hearing was to be given. Against that, a review petition was against that. An SLP was filed, which was withdrawn with a liberty to file a review petition. The review petition was filed, which was dismissed by the division bench of this court.
Holding renewal was not permissible.
Against that, another SLP has been filed, wherein there is no interim orders passed. Mr. B. Sharma, the learned counsel appearing on behalf of the petitioners, respondents further submitted that pursuant to the order passed by this court on 24/1/2023 in WPC number 5313/2017, isn't that?
31st May 2024.
Huh?
31st May 2024. 165.
No, isn't this the case? 5313.
The original one, my lord. Page 1 of my compilation that I have provided. There is the judgment by you.
The petitioners, all these petitioners were evicted However, they forcibly again entered into possession as have been noted in the speaking order dated
13th March 2023.
as have been have forcibly entered into possession
31/1/2024.
on 18/3/2023.
15th.
They have entered it into possession.
On the basis of the order dated 13th March 2023. But after this order, your lordship, they have taken it.
The submission of the learned counsel for the petitioner have been duly noted, whose only contention is that the petitioners herein were not heard, not given a reasonable opportunity of hearing. However, the speaking order dated 31/1/2024 na,
Yes.
shows otherwise. This court further finds it very pertinent to observe that the catering policy of 2017 is in vogue. And even and under such circumstances and wherein the scope of granting extension or renewal is not there. This aspect of the matter, which was held by this court in its judgment dated
31st, 23.
24/1/2023 in WPC number 5313/2017, have not been interfered with either by the division bench or by the Supreme Court. Under such circumstances, taking into account that the petitioners have not been able to show any valid ground on which the impugned notice dated 31/7/2024 is required to be stayed, this court rejects the interim order. This court further makes it clear that the pendency of the instant writ petition shall not bar the respondents to take action in accordance with law.
Much big.
I could have dismissed it.
Lordship,
Eh?
for my sake, your lordship. My humble request for professional sake, for our professional sake.
Dorong and Sunitpur.
If any claims, my lord, they should have gone for the submitting D3. That is the first document lordship will find. That is the, I apologize, my lord, I could not bring the original. It's with the director of Urang. It's in transit, my lord, it will come by next week perhaps. So this is the preliminary notification. Whereby, my lord, the DC's deputy commissioners of Sunitpur and Dorong were appointed collectors.
This is Dorong and Sunitpur.
Sunitpur, my lord.
Mongoldo and Tezpur subdivision.
Yes, my lord. We have not touched anything in
Revenue
Morigaon,
Sagar, Dolgaon, Dhikiajuli and Thelamara,
my lord.
Orang National Park.
My lord.
Then
Then documents, my lord, will see, I have also annexed one map. There is a part of that. That's a preliminary notification, my lord. The second page is, second page which I've given, my lord, it's appointment of those DCs, concerned to DCs, my lords. Then DC Mongoldo issues a communication, DC Dorong issues a communication to the Additional Chief Secretary at Environment and Forest that no objection has been received. And the other set of paper, my lords, same, my lords, Sunitpur, the learned Deputy Commissioner Sunitpur passes a speaking order that no claims and objection has been received by his esteemed office, my lords. So the final notification comes, my lords. Final notification under section, my lords, 35.
this is the one in Assamese
Yes, my lords.
on 11/2/2022.
My lord, that was a speaking order, perhaps, or vernacular.
On 25,
Yes, my lord.
25
my
August
lord.
2020.
25 August.
Their petitioners' land do not fall within this.
No, man. Even in fact, my lord, their title is also disputed from page 37 to almost a running, these are land documents of 1813 and this is Kiras Patas, my lords. I perhaps Tosi
Hiraspatta means Purity Patta.
No, here's a period for 1 year, my lord. There is no whisper whether they were extended to their legal heirs or not.
So these lands have nothing to do with Oran, their second,
No,
second notification.
no.
Because the second
fact, my lord-
notification is for the district of Dorong and Hunit.
My lords.
Whereas these lands fall in Morigaon.
Morigaon. Purportedly, that is their claim, my lord. In fact, my lord, if sees, my lord, page 82, page 85, page 86, my lords, their area, if we, in spirit, if we read these letters, they have communications, their area has not been named till now. They're residing in shore areas. They're claiming that the areas should be renamed as Kasem Shore. And then, my lord, Kasem Shore, my lord, erosion affected areas, they are occupying shore areas, they are asking that rename this area, bring it within Morigaon district.
Now, where does the Orang National Park fall?
My lords, it falls within a part of Sonitpur, within a part of, my lords, Dorong.
Not in
But
Murigaon.
No, no.
You sure?
I'm sure, my lord, I have taken instruction of the divisional forest officer or the director, my lord. My lord, he has explained to me what would happen if lordship, bears with me for a moment, my lords. The persons I have demonstrated, they are my lords, landless and they are affected by, admittedly, they are affected by erosion. Now, my lords, they go and occupy shore and they say, now this is our land, we are within Morigaon. And in fact, my lord, there was a first round of litigation, my lord. The petitioners withdraw those petitions, seeking, my lord, they will submit representation before the DCs of Morigaon, Sonitpur and Dorong. And there, that cause of action, they have withdrawn, my lords, and this present writ, my lord, same prayer has been forwarded again.
What are the earlier orders passed by this court?
My lords, is my lord annexed in. In fact, I have a copy of the writ petition, my lord, same prayer. My lords, the order starts at page number. Hey, holy. When 231 it starts, it culminates into an order, my lords. Two 288. Petitioners council withdraws this petition and seeks liberty to file representation before the DCs of.
So they have withdrawn the earlier petition
Yes,
to
yes.
approach them.
Yes, my
But that is only limited for cutting the jute.
lords.
That is
But
the
my lord,
only
that-
order.
My lord, that
Was the
petition.
interim
Yes,
prayer, my lord, for
There's
cutting.
another order seems at page. This is the order. Where they say that they want to cut their jute.
My lords.
That is the 3,000 bighas of land. Now what do they want?
Same prayer, my lords.
No, not the same. Now the same prayer is different. Now they want something else.
No, my lords, they want the land back and compensation.
No. Earlier it was different. Now you see what they want. Yes. They want.
Same.
Now, earlier, if you see, kindly come to page
80,
145. 145. They have enclosed this order many times. The petitioner herein claimed that they are in occupation of 3,000 bighas of patta land situated in Swerin wherein they have carried out cultivation jute. Recently, the BIA have evicted the petitioners from the said land. The prayer made by the petitioner's counsel is to the effect that his clients should be allowed to harvest the jute which have been cultivated by them, as otherwise the same would lead to serious loss and injury to the interest of the petitioner, are therefore seeking a mandamus directing it to allow them to harvest the jute. However, I find that there is no such request, and therefore they sought
My lord,
for
I
leave.
have a copy of that petition.
Ah.
4916, my lords. Same prayer, my lords. Anjumna. There, it'll be. It's 4916, same prayer.
Now, therefore, they went, submitted the representation.
Now their cause of action has arisen because the DCs are sitting over so-called purported representation. My lord, that is a prayer, but similar prayer, not the alphabet here and there.
So they withdrew
Which one?
and same thing.
Same.
Now, as per you, they say that the government had evicted,
My lord.
not the forest.
My lord.
Who has evicted you?
My lord, the authority, my lord, including deputy commissioner and other staffs.
Not the forest.
Armed forces. We do not know, my lord. Who
Huh?
are the authority?
What
Deputy
is this?
commissioner, circle officer, they came to our land, evicted us. And what my learned friend said,
Okay, then whom did you submit the representation for harvesting?
my lord, that representation submitted by the petitioners
To whom?
to the deputy commissioner Morigaon
Ah.
and deputy commissioner Dorong, my lord. And what happened, my lord, what my learned friend is saying now,
Hmm.
all things, my lord, affidavit has been filed by the deputy commissioner, Morigaon. Representation, regarding representation, everything, my lord, Morigaon district is doing. And your lordship would be pleased. to
Kindly
see-
come to page 216. What is your representation? 216. This is your representation pursuant to
T16.
the withdrawal. Paragraph 8, 216.
Yes, ma'am. Paragraph 8. That the jute cultivation were cultivated by the petitioner over said B schedule land. And the jute is ready for harvesting, but as the petitioners were evicted by the authorities, the petitioners were not allowed to harvest the jute cultivation by authorities. The value of jute is 1 crore 50 lakhs. The jute is drying out, and within a short span of time, it would be completely dried up, and the petitioners will suffer loss of aforesaid amount. It is pertinent to mention here that the petitioner raised cultivation of jute by spending huge amount.
So, Mr. Sheikh,
My lord.
your prayer in the earlier set of writ petition is same as today.
Yes.
In that writ petition, you made a submission before the court that look here, kindly allow us to cultivate the jute.
Yes.
And as such, the court directed you to submit a representation. And you withdrew.
No, your lordship said that, you see, you did not approach the deputy commissioner. So I approach.
No.
Ah.
Yes,
Ah.
for cultivating
Yes.
the jute.
Right.
Now, your representation is only to that.
1 minute. Return the BC to land. Return the BC to land. Your lordship would be pleased to see.
Where?
Pleased to see my prayer.
Where in your writ petition?
Yes, my lord. Best
No, 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 no,
Hold
no,
on.
no. In your representation.
representation. No, my lord, regarding representation, what happened, my lord?
You
In the
made the
writ
same prayer.
petition.
No, Mr. Sheikh, you made the same prayer in the earlier writ petition.
Yes.
Earlier writ petition, it was withdrawn on the basis that you made a submission before the court that look here, there are jute lying, kindly allow them to be harvested. Accordingly, this court says that how can I issue a writ unless you approach the authorities? And accordingly, you withdrew without prejudice to your claims which you have made in the earlier writ petition, submitting that you are going to submit a representation. Very well. You submit a representation, kindly allow me to cut the jute.
My lord, here what happened, my lord? The deputy commissioner, we did not pray before the deputy commissioner, the land may be returned.
Who will get, the court will give.
Yes, my lord,
Why?
court is to return, my lord, because court is to return because, my lord, they have taken.
File a suit, file suit.
My lord.
File suit if you have any land. This is not the court. Which is
No,
going to do.
your lordship would be pleased to see.
Nothing doing,
This is a
nothing doing,
Patna land.
file suit.
But regarding this jute cultivation, my lord, this cultivating the jute,
Jute has gone, water.
my lord.
This matter earlier came up before the division bench once, wherein the question arose out there as regards what has happened to cultivate the jute, harvest the jute. We took the instructions from the authorities out there. While I was sitting in the division bench, the authorities came in, then nothing remains. Mr. P. Mohanto was the earlier counsel out there.
But there are some tomato trees and brinjal.
My lord, your lordship,
Tomato trees and brinjal trees.
your lordship would be pleased to see that Patta land has been taken away.
Patta land?
Yes.
Prove it.
My lord,
File suit, not here. Not, this is not the court. To
Well,
whether it is
why
Patta land.
without compensation, my lord, land will be taken away?
Huh?
Without compensation, why land will be taken away?
You can very well get a suit or decree that without the compensation. First, you have to prove that this is your land.
My lord,
The 3,000 bighas of land is there, which portion of the land it is. How can this court look into it?
Patta. I have given the Patta. Patta I have annexed with this petition, my lord.
Fantastic. Prove the patta.
Yes, my lord.
Okay. Whose signature it is? Page 51.
It is
You want this court to be the civil court. Whose signature it is?
40.
Page 51.
40.
Whose signature it is?
That's my lord.
Okay. Whose signature it is?
Job on the copy is there, my lord.
No, whose signature it is? Where is the signature of this person?
My lord.
This is only a photocopy. Not only that, this doesn't bear any signature. Handwriting is not eligible. Absolutely no. This, you can't transform this court into a go before a civil court. Nothing doing. I hope
Yes, my lord.
heard
That's
Mr. M.
permission by
Sheikh,
the
the learned counsel appearing on behalf of the petitioner. Anybody from the revenue? Everybody a party. Ms. P.R. Mohanto appears on behalf of the Revenue and Disaster Management Department of the government. Mr. D. Gogoi appears on behalf of the respondent number 2, 4, 5.
Apune এইটা sorry.
Who appears for the government? Mr. H. Sharma. The H. Sharma appears on behalf of the Ikita Didibahas. Commissioner A2. 6, 7, 8, 9, 10.
6, 7, 8, 9, 10.
Ms. So-and-so appears for respondent number 1. Give your names properly. The petitioners herein who are 73 petitioners have joined together and filed the instant writ petition seeking a direction upon the respondents to return the B schedule land to the petitioners, or in the alternative, to acquire the land and pay compensation in terms with the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. This court duly takes note of. In addition to that, the petitioners have also prayed that the respondents' authorities may be directed to allow the petitioners to harvest the juice cultivation standing on the B schedule land for the interest of justice. It is relevant to take note of that the Schedule B land is a plot of land measuring about 3,000 bighas situated at revenue villages. Tengaguri, ekita likhi dibo, ha? Page 35 of the so and so, so and so. It is apposite herein to mention that prior to filing the instant writ petition, the petitioner have joined together to file, had joined together and filed a writ petition bearing, which was registered and numbered as 4916/2023. The relief sought for in the instant writ petition is the same with WPC number 4916/2023. In the said writ petition, when the matter was taken up, it was submitted that the petitioners be permitted to harvest the jute which the petitioners have cultivated in the land which have been specifically described in Schedule B. However, this court, taking into account that the petitioners having not approached the concerned respondent authorities, have not directed the petitioner to approach gave the liberty to the petitioners to approach the concerned respondent authorities. And under such circumstances, the said writ petition was withdrawn without any liberty. Pursuant thereto, various representations were submitted to the respondents numbers 6, 7, and 8. On 31/8/2023. A perusal of this representation shows that the petitioners herein claimed only that they should be permitted to harvest the said jute, which is valued at rupees 1.5 crores. Thereupon, the petitioners having not received any favorable response, the instant writ petition has been filed. This court have duly heard the learned counsel appearing on behalf of the petitioner as well as the various counsels, the counsels who represents the respondents. Pursuant to the order dated 30/7/2024, Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, has placed various documents which would show that in pursuance to the provisions under Section 35 of the Wildlife Protection Act 1972, the 200.32 square kilometers of area have been notified as the additional as the second edition of Orang National Park. The learned counsel appearing on behalf of the Forest Department further drawing this court's attention to the various notifications and corrigendums submitted that the Orang National Park is situated in the districts of Mongoldoi and Dorong and Hunitpur and not in Morigaon. In addition to that, he therefore submitted.
Excuse my lord, in the submission of my learned friend that not a single area of Morigaon is taken in the Orang Park.
It is, but I'm recording that.
That may be recorded.
He therefore submitted that the that as per the second edition of the Orang National Park, no land of the petitioners have been brought within the scope of the said notification. In addition to that, the Learned Council further submitted that notifications were issued whereby calling for objections, and there was no objections also being filed by any person. And it is under such circumstances a speaking order has also been passed on 22/7/2022. The Learned Council have placed before this court, the documents which have been placed before this court are collectively kept on record and marked with the letter X. In the backdrop of the above, if this court duly takes note of the case of the petitioners, it is difficult to ascertain the petitioner. The petitioner claims that land, that they are owners of the land which have been specifically described in Schedule B to the plain of the writ petition. The question arises as to whether this court, in an exercise of the powers under Article 2 to 6 of the Constitution, can at all adjudicate the said aspect of the matter. In the opinion of this court, such adjudication would require detailed evidence being tendered, records being perused, which can only be done by a court of civil by a competent court of civil jurisdiction. In addition to that, the lands of the petitioners, the claims of the petitioners, all the petitioners are respected to their are individual claims. And such claims cannot, as regards their right, title, and interest. Such claims cannot be decided in a proceedings under Article 2 to 6 of the Constitution. Under such circumstances, this court is not inclined to entertain the instant writ petition. If the petitioners herein are aggrieved, they are always at liberty to approach the competent civil court, seeking their right, title, and interest over the land, as well as for recovery of possession or other reliefs as deemed fit.
Polish. Right.
Here's what happened. Have you paid the money?
Lordship, we have received the instructions regarding this matter.
Have you paid the money or not? Mr. Gogoi, have you paid the money?
My lord, the government has moved up revenue department, my lord, for some vetting of the entire proposal. It is lying with the revenue now. We have moved on, my lord, 7th of August. This is the latest instruction I got, my lord.
What is all these things? Return the land.
Well-
Return the land.
No, they are doing it, my
No,
lord.
no.
Not that, my lord.
Return the land. You file another petition. We take it with this. I'm sitting out here. File another petition for quashing of that. And taking into account all these things. We quash that notification on on land acquisition.
The last one. is about it.
Yes, yes, challenge it.
So
We-
she will give us some time. It will be
No,
done, my
nothing
lord.
doing.
I
Mr.
understand, my
Gogoi,
lord.
Mr.
Yes,
Gogoi,
ma'am.
one thing, what you are trying to do out here is buy time.
No, that's-
Yes, absolutely. What business does the department has on preliminary estimates? This has been done on the basis of a consent award. Then what business do you have? And this consent award, do you mean to say that the revenue had adjudicated this consent award without taking your concurrence? And you are asking for preliminary estimate and all?
Lordship will kindly reflect it in the order.
No, nothing doing. I'm
Day
not
after-
going to reflect anything. This is a
Day after
fit
tomorrow.
case where you need to hand over the possession. Where is that morgue? Morgue. Good. You'll
No,
get
no.
more money.
No, not
No,
that
no.
case, my lord. Not that case, my lord. That-
Is the morgue?
The land of the petitioner, apparently the morgue is in its.
Yes.
Yeah, more, yes.
Remove that morgue. Have a five-star hotel. It's a good land. 2 bighas of land.
Let me day after tomorrow. I will.
2
convey.
more there.
At least, my lord.
Mr. Gogoi,
I understand. my
this
lord.
court have these aspects of the matter. I think this court have knows what is how it is to be done. Don't come up with all these silly excuses. Here is a case, simple. Otherwise, are we to understand where is that revenue? No, not you. Your revenue would not help. Where is Mr. Arbor Pujari?
My lord, it's not well. It's not well. my lord.
Okay, we adjourn it only on that ground, not on the basis of this. Take it back. Take and give it to your authority out there.
Yes, yes. I will
This court is
convey-
not going to appreciate it. The revenue department 100% have, because it is a consent award. And if it is a consensus, therefore the director of medical, there will be some document also it will show. How can you raise?
One instruction of the revenue was 5/8/2020.
That is marked as C2.
It is clear. I've seen it. They categorically say that they have done it.
Director is forwarded to the government, not government. has-
This is a clear cut thing that, okay, why you want to go back to the stage of preliminary notification?
I don't know that they have misunderstood the entire. matter.
And that too well, Anup Kumar Burman, the director of medical education, gives his proposal to the finance.
No, to the health department, government. He has routed it to the government.
He gives it to the whole. Then again, now we are going to see. Tomorrow you bring in the finance.
Lots.
It has been submitted that Mr. R. Borpujari, the learned standing counsel appearing on behalf of the revenue department, is not well. Taking into account the above, list this matter again on 21st of August 2020.
Record my lord prayer also that I will have the specific instruction on Wednesday. At least I can convey.
In addition to that, Mr. B. Gogoi, the learned counsel appearing on behalf of the Director of Medical,
No,
the
Lordship, it's a
Health
health
and
department.
Family Welfare Department
Medical education and research department. my lord.
shall, huh?
Medical education and research department.
Medical Education and Health Department shall obtain the instruction as sought for by the order dated 6/8/2020
On Friday, my lord.
without fail.
Thursday, the whole Friday, but I will come up with something. my lord. Let it be
I'm
on Friday.
fixing it on 21st, giving you more time.
Yes, yes.
Today is 12.
Yes, yes.
So I'm giving you take the next Wednesday,
What's-
not this Wednesday, next.
Oblige.
I hope the file does not become, the order sheet does not become thicker than the file because of you.
My lord, from,
Yes, what is this?
there is no response from the government, my lord. Whether you-
RP Sharma Learned senior assisted by so and so. What is your matter?
That will not claim of compensation for the death of the
Pay
detainee.
compensation of 25 lakhs to the petitioner's family as promised and assured on account of the death of the father, the Dulal Chandra Paul, while in jail. Who assured you? Who assured you? Who assured you that they will pay?
Chief Minister, my lord, whatever, my lord, he died while he was being taken to medical college, was admitted. He was in jail. Then, my lord, there was a big Andolan and recession in Sonipur district. Ultimately, the then Chief Minister as well as his the Council Department, Home Department issued to pay compensation and take the body. Then only they've taken the body.
And what happened?
Ultimately, in my lord, the foreigners case review was filed, my lord, and this judgment of this court has clarified that since the man is dead, the
You died in judicial custody. So you are asking for 25 lakhs. Fantastic. Constitutional thought. Yes, why no reply to the constitution?
Lordship, that is not the case.
What is the case?
That is not their case that they were, the father of the petitioner died in judicial custody. That is not their case. He was declared as a foreigner by the FT. Challenging that, they have approached the High Court. High Court dismissed it. He was in jail. While in jail, Lordship, he is expired. The person expired. According to some agitation by Bengali Juba Satra Parishad or something like that, some agitation. To come down, Lordships, according to him, that some promises were made by some public lordship, that some promises from the petition I am stating, Lordship, that some promises were made that they will be giving 25 lakhs. Now they are asking for a mandamus. Whether mandamus can be.
Oh, no mandamus.
That is the case, Lordship.
But don't you think he died out there? Whether there was any inquiry report?
No, Lordship. Regarding that, Lordship, there is no complaint, nothing. Nothing, Lordship. Natural death, most probably. So there was nothing. So he is only asking for that.
Postmortem is what?
Asking for that.
You have
25.
enclosed the postmortem?
Yeah, he has not annexed. Yes. Yes, postmortem is there.
Where? Where does it say?
Postmortem, ne?
No postmortem.
No, Lordship.
What case you are
That
making
is
up?
not their case at all, Lordship. They are asking that some promises were made by somebody. Accordingly, that payment should be
No,
made.
no,
Whether
no, no.
mandamus
This
can
cannot be your
issued.
case of mandamus. Somebody comes up and gives everything, that cannot bind it.
But that is the case, Lordship.
That judgment of the Supreme Court na Constitution bench, what does it say? Where if a government official represent the petitioner having been promised and assured by the government and representative, again, they would be paid. No writ on this basis. You want to make a case for judicial area, it's a different thing. In jail custody, a
Yes, Lordship.
person has done
In that case, it
illegally.
would have been a case, Lordship. But that is
your
not their case.
No judicial. Not. Mandamus cannot be issued on this. No case. Hello, dismiss. Heard Mr. R.P. Sharma, the learned counsel appearing on behalf, senior counsel appearing on behalf, assisted by so and so, appearing half of the petitioners. How many petitioners? Petitioner.
Myself,
Mr.
2,
H.
3, and
Sharma appears on behalf of the respondent
2, 3 and
numbers
4.
2, 3,
Oh,
and
sorry, 1, 3 and 4, Lordship. Two
1,
finals.
2, all 1, 3, and 4.
Lordship.
And Mr. B. Goy appears on behalf of the respondent number 2. The case of the petitioner herein is that the father of the petitioner was declared to be a foreigner in a proceeding being FT bracket 9 case number 223/2017 by the Foreigner Tribunal number 9 Punitpur at Dhikazali on 11/8/2017. Being aggrieved, the father of the petitioner approached this court by filing a writ petition being WPC number 7320/2017, which was however dismissed by judgment dated 18/1/2019. Thereupon, the father of the petitioner was lodged in the, what is that? They say to be, it's not a jail, nah?
Detention.
In the detention camp. While he was in the detention camp, because while he was in detention camp on 13/10/2019, the father of the petitioner expired. Thereupon, there was a mass movement by various organizations, including the All Assam Bengal Yuva Chhatra Federation. In view of such agitation, it has been stated that the petitioner would be paid, the family members of late Dulal Chandra Paul, the family members of late Dulal Chandra Paul, who was the father of the petitioner, would be paid an amount of rupees 25 lakhs as compensation. However, as the said compensation have not been paid, the petitioner has therefore approached this court seeking a writ in the nature of mandamus. This court have duly heard the learned counsel appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondents. It is well settled that a writ in the nature of mandamus can be issued by this court for enforcing a duty imposed upon a state within the meaning of Article 12 of the Constitution. The duty so obligated upon the state has to be on the basis of certain statute or executive orders having the sanction of law. Mere representations given by any official without having the authority to do so cannot bind the state authorities in order for this court to issue a writ in the nature of mandamus. In the instant case, there is nothing on record to show that any authority duly empowered and compelled by and empowered on the basis of authority duly empowered, or for that matter, there is any statute or executive instructions which stipulate, which on the basis of which this court can issue a direction to the respondent authorities for making payment of the compensation as was promised, allegedly promised by the certain officials of the government. Under such circumstances, this court finds no merit in the instant petition for which the same stands dismissed. Yes, what is this? I passed a long order, long time back, and the matter has come all of a sudden. Why?
Your Lordship, on the
That the petitioner are in possession of the even the
2022,
further cases that
status
the
quo order
court
has
have
been
initiated
passed.
proceeding.
But yes, my lord, since long it is not listed, my lord, since motion, notice of motion, my lord.
Your Lordship, one of the petitioner has informed me that the eviction case has been disposed of. Your Lordship, to verify the same, Your Lordship, 7 days time may be granted, Your Lordship.
In the eviction case, what happened?
Lordship, yesterday, one of the petitioners has informed me that the case is dismissed, Your Lordship. To verify the same,
Your case has been dismissed.
eviction case filed by the railway, Your Lordship, has been dismissed, Your Lordship.
By?
Your Lordship, to verify the same, Your Lordship, 7 days time may be granted, Your Lordship.
But this is an order by which. Oh,
Notices were issued by the state officer,
what happened to those?
but
I said, don't disturb now till you dispose of the eviction cases.
yes,
What
well-
happened?
latest instruction, I don't know.
Okay, list the matter again on. 28th of August 2024, on which date?
I'm sorry, my lord, first week of September. My lord,
Why? Where is this?
No, my lord, I will be out of sessions, last.
Get hold of anybody else. It is here, Maligaon. Oh, file date,
Then, 22nd, my lord. Before that, my lord.
4:30?
No, 22nd.
4:30 today?
Kindly, my lord,
4:30. Get your instructions, 4:30.
Today-
What has happened? It is out here.
No, my lord, I know.
Get the instructions out there. What is this?
Sir.
You can't keep these matters pending
My lord
unnecessarily.
is fixing on the 28th. I am saying, my lord, prior to that, my lord.
And
No
test,
issue, but
21st.
my lord,
List the matter on 21st, on which date Mr. K. Parasa, the learned standing counsel appearing on behalf of the railways, shall apprise as to what orders have been passed in the various eviction cases as mentioned in the order dated 23/3/2022.
I'm sure, like.
17.
Yeah, please, Dr.
Mm.
Lordship, may kindly peruse the last order dated 6/5/2024. That affidavit is next to
What are you asking?
for compensation matter,
For what?
killing by extremist,
Huh?
killing by extremist
Killed by extremists.
of the central government scheme, my lord. Page 1 or 2.
But the difficulty is that lordship, the communal harmony, the respond number two is not a proper party so far as the claim for the compensation is there. So I'm filing the affidavit, I already received it, I'll be filing it by.
You're filing the affidavit. It's the speech order, the learned counsel who represents.
The respond number 1 and 2, lordship.
Respond number 1 and 2 submits that the affidavit is to be filed within a week's time.
Yes.
List the matter again on 6th of September 2024. In the meantime, the petitioner would be at liberty to file a reply.
Respondent number 11, 12, praise for filing affidavit.
File it. The other respondents are also given the liberty to file their affidavit in the meantime. Yes, what is this?
I filed a reply against the affidavit of opposition filed by the respondent.
Huh?
That is.
Oh, this is tagged with me.
And it 4-5, respondent number 4-5 file affidavit.
Yes, what case?
I think
He has a good case. This person has only passed class 8.
my lord, that is the dispute, my lord. Your lordship kindly see the draft rule which I have annexed. My respondent 4 and 5 annexed, my lord. And that is, my lord, not conformity with the draft rule he has annexed. My He has not annexed his stated, my lord. Yeah, that's why, my lord, HT's affidavit is required. I'll be on 2 weeks' time to file affidavit.
I've given many time.
No, my lord, regarding HT, I have not taken time. But regarding, my lord, 4 and 5, my lord, the district judge, my lord, when the district judge has filed affidavit, and
So every time you represent one
my lord,
respondent, every
I
time
thought that, my
I'm
lord, that
going
will
to
be
give a
that-
time.
No, that will be enough, my lord. But now, my lord, your lordship kindly see one line, my lord, which was annexed by the respondent 4 and 5, that is not conforming with the, my lord, what he stated, my lord.
Show me your, yeah, what is that qualification required? As per your rules.
Page 82.
Yes. Must be class 8 pass, beyond.
Must be a class 8 pass beyond, my lord, that is the benchmark, because it's a case of promotion, my lord.
Hmm.
In promotion, my lord, 5 year, at least 5 year length of service is required. But he says that in case of promotion also, my lord, those who are past SSLC, they will get. So that's why, my lord. But he's talking about, my lord, in his writ petition, my lord, he's talking about my lord, another draft rule, my lord. But it is still, it is on the draft rule. In various states, probably, my lord, one stage he is getting it, my lord. It is still draft.
How can you have class 8?
My lord.
How can you have class 8? You have degree.
The peon, my lord, to process server.
Process server. After all, nowadays the process server is not a simple person out there. He has to have the GPS gazette and all these things. You cannot have like that.
And it is case of promotion, my lord.
And a promotion, a person who is a direct recruit, he has to be HSLC.
Must.
But a person otherwise is a class 8.
My lord. Yes, your lordship, kindly group D, my lord, D1, D2, my lord, that is benchmark is my lord, my lord, that is qualification is my lord, SSLC pass, that is class 8 pass. In fact, my lord, if he is a metric pass, my lord, he'll be disqualified. Here's a notification, my lord. If he is overqualified, he'll be disqualified for that post, my lord.
If it was a state government rule, we would have set aside this. Now our
yes.
high court and all this, you have done all these things.
Give me, my lord, but I'll confirm it from registry, my lord, in 2 weeks' time, my lord. I'll just now, my lord, I have seen that, my lord.
Mr. T.J. Mohanto, the learned senior counsel, who is also the standing counsel of the Guwahati High Court, is directed to obtain instructions from the registry of this court and file an affidavit as to what is the qualification required for promotion to the post of process server from
On grade D2 to D1.
yeah, to the promotion of process server.
Oh, my, correct.
This is the matter again. These matters, yeah, we need to finish it off. This is the matter again on 27th of August 2024. The affidavit be filed by 21st of August 2024.
If you allowed to file an additional affidavit.
Whatever you file.
Big lord.
Don't file it at the last moment. 27 matter has finished. These are tagged up matters with me. I don't like it to remain there for the last 2 years.
My
Yes, what is this?
The Patta land, I have been in possession of the Patta land since 1986, my lord. Now, my lord, when I filed my application for demarcation, my lord, suddenly into notice was served on me, my lord. They're saying that I am occupying government land, my lord.
Where?
In notice, my lord, page 42.
Page?
Page 42, my lord.
40.
Yeah, yeah, in particular 42, my lord. Then annexure 9, 40. Yeah.
And where is the patta?
Jamabandi, my lord, at page 22, 21, 22, my lord. vernacular, and in translated vernacular, my lord, page 18.
Page?
In English, page 18, my lord, annexure 2. My lord, we come to the vernacular, my lord, page 21. In 1981, my lord, I paid the premium, my lord. Originally, it was a annual patta land. I purchased the possession, my lord. And accordingly, I paid the premium, my lord. In 1986, I was granted the mutation, my lord.
Patta?
Patta copy, I have got annexed.
Huh? Where is your patta?
I have not annexed, my lord.
Patta is 17, you say. You will have the patta.
At page 22, my lord, may I read, my lord, the order, my lord.
22.
Yes, 22.
Read it. Where?
At, down below at in Assamese, my lord, at Go, Sithat Paskora, property Homohata, 14/2/1986, Tarikhor Hukum Mote, Pori Thutre, Sari Dagor, Tini Kotha, Tini Biga, Dui Kotha, Unesh Lesa. There is another Dag, my lord, Dag 6. In Dag 6, my lord, 2 Kotha, 1 Lesa, total 4 Biga. Mut 4 Biga, 2-3-4 number স্থলৰ লগত 5 নম্বৰ নামজাৰি হয়। So I am number 5, my lord, Kovilas Prasad. My name appears on page 21.
Yes, government, what is this?
Lordship. From the petition, it reflects that my learned friend's client is possessing his land in Dag number 4 and 6. And the notice is regarding Dag number 8. Page 39, vernacular one. So most probably he is additionally possessing the land in Dag number 8.
No, I have no other land, my lord.
So you do one thing.
Then Lordship, if he is occupying 4 and 6, in that land he will not be disturbed because this is regarding 8 only.
No, I will be served with notice, my lord.
Yes, most probably he is occupying.
No, I am not occupying.
That is a different aspect, Lordship.
I
But
filed by-
this is regarding 8 Dag number.
Kindly see, my lord, my application at page 34, my lord. This is for demarcation, my lord. Page 33 and 34. On 22/12/21, my lord, I filed a application. And the notice was served on 17/1/2022.
Yes, Lordship, he has paid for demarcation, those notices were served. Thereafter, it was seen most probably he is occupying some 3 bigas or some lessers of land in Dag number 8. So he was directed to vacate that land.
Neighboring persons were also served with notices, my lord.
Okay. Then I do one thing, let them proceed with the eviction or in terms with this, but
Yes,
without
Lordship,
disturbing
regarding
your
8, Dag
possession in
number 8.
these stuff. I don't,
4 and 6, my lord, yes, my lord.
Yes, Lordship.
you have only right over this.
4
Yes,
and 6.
4 and 6.
Yes.
and he is wrong, if he is
Mr.
wrongfully
R.
occupying in
Chakraborty, the
that
learned
8,
counsel appearing on behalf of the petitioner.
My application for demarcation may also be, my lord, processed. Closed off.
Each
regarding the
appears on
demarcation.
behalf of the respondent number 2, 3, and 4. So appears for respondent number. The case of the petitioner herein is that the petitioner is the owner of a plot of land, of 2 plots of land. Included in Potta number 17. One plot is an area measuring 3 bighas 2 kata 19 lechas covered by Dag number 4, and the other plot is 2 kata 1 lecha covered by Dag number 6. The said land is situated within Moza Khorupathar village Borbali in the district of Karbi Anglong, Golaghat, Assam. Full stop. It is seen that the petitioner had sought for demarcation of his land by the request made on 22/12/2021. However, the said no such demarcation has been carried out. Full stop. The petitioner herein is aggrieved by a notice issued on 17/1/2022 by the circle officer, thereby directing the petitioner to vacate the said land, which have been mentioned in the schedule to the said notice within a period of 7 days. It is opposite APPO to mention that the land mentioned in the said notice is a plot of land measuring 3 bighas 4 katha 18 lechas covered by dag number 8, which is the government dag, in village Borbali in the district of under the revenue circle, under Horupatha revenue circle in the district of Golaghat. There is nothing on record to show that the petitioner has any ownership over dag number 8 or even a bona fide claim of right involved. The petitioner's claim is strictly restricted to 4 bighas of land, strictly restricted to 3 bighas, 2 katha 19 lechas, and 2 katha 1 lecha covered by dag numbers 4 and 6 respectively of and included in Miyadi Patta number 17 of village Borbali
Yes.
under Moza
Horupatha.
Horupatha.
Village yes, as per notice, they say it's Tengrajan.
Moza, yeah. Under Moza is also Horupatha.
Oza is Horupatha. As per their
Gaon,
notice, but
Gaon Tengrajan.
into notice, they say it's village Tengrajan, but I am in village Borbali.
Where is the thing?
Page 39.
Huh?
Page 39, Lordship. Proti, Nam, so-and-so, Pita, so-and-so, Gaon Tengrajan. And down below, Topsil, Horupathar Mojar, Borbali Gaon, 8 number, Hadaron Sorkari Dagor, 3 bighas 4 katha, 18 less.
His address has been shown as different. Village Borbali. Under Moza Horupathar, under Moza and Revenue Circle Horupathar in the district of Golaghat, Assam. Under such circumstances, this court would not like to interfere with the notice dated 17/1/2022. However, this court observes and directs that while carrying out the eviction in terms with the notice dated 17/1/2022, the respondent authorities shall not disturb the possession of the petitioner in respect to the lands mentioned, land covered by measuring 3 bighas 2 katha 19 lechas and 2 katha 1 lechas covered by dag number 4 and 6 respectively under Miyadi Patta number 17 village Borbali in the district of so-and-so. This court further directs the circle officer, the Horupatha Revenue Circle, to carry out the demarcation of the land belonging to the petitioner as per its request made on 22/12/2021. The same be carried out within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number. Circle officer is 3. The above, the instant petition stands disposed. Interim orders, if any, stand vacated.
Your Lordship, I am on behalf of Mr. H.R. Chaudhary. As per instruction of my learned counsel, the respondent have not filed an affidavit in opposition.
We are yet to get the instructions, Lord. May I pray for some time? Lord?
Mr. H. Sharma, the learned counsel appearing on behalf of the respondents, submits that he requires 3 weeks' time for obtaining, for filing the affidavit, obtaining in the instructions. Court, taking into account the said prayer, fixes this matter again on 18th of September 2024. The stand of the respondents be brought on record by filing an affidavit on or before 11th of September.
Everyone.
Yes, what is this?
Your Lordship. Lordship, actually, this was regarding a eviction of a market, Lordship. And construction. Was regarding, Lordship, eviction of a government land, Lordship.
Market,
Evicted.
evicted.
But what has happened, Lordship? That project, Lordship, some World Bank project was there, which was to be constructed there. But that project has stalled since 2022. After this, to some blacklisting of the contractor.
Then?
Has not proceeded, and they are still paying their respective. Market is still there.
Where? Yes, yes, what is this?
Lordship, with regard to the installment of the project, that information I do not have. Lordship, the instruction was that while the construction was initiated under the apart program, Lordship, there was due consultation with the all market dwellers, and they were given a place just adjacent to the existing market. And thereafter, the construction was initiated. And with regard to the installment, that information, Lordship, I do not have.
Anyway, you
that-
file an affidavit, there is no stay.
Yes, sir.
File an affidavit. Mr. B. Chaudhary appearing on behalf of BTC.
and
submits-
agriculture.
BTC
And agriculture. Lordship.
and Agriculture Department submits that he has instructions which we like to bring on record by filing the affidavit. List the matter again on 23rd of September 2024. The affidavit be filed by 17th of September 2024.
Apply. 52.
Pursuant to my lord's last order, we have filed the affidavit.
Oh, yes, that one.
The report of the
Lordship,
expert.
Mr. My senior is on legs, K. Talukdar is on legs. K. Talukdar is on legs.
Madam, I know it has been a long day for you. And then because of that, your voice have substantially reduced. But tell me why, means nothing can be heard from you.
My senior is on legs, Lordship, K. Talukdar.
Council for NHID.
Huh? Okay, you filed the affidavit when? Today?
No, my lord, on Friday, that was
Okay.
called for, my lord, it's on record.
Yes, we do one thing, we have it on some other date. Yes, Mr.
I have filed, my lord, everything.
You have filed affidavits and they have also filed. All affidavits filed. Okay, we'll take it up on when?
Tomorrow, my lord.
Pursuant to the order dated 24/7/2024, both the petitioner as well as the NHIDCL have filed their affidavits. The same have just come on records. List the matter again on 27th of August 2024. We'll try to dispose it of on that.
Can you put on Thursday, my lord? Not possible. This
27 now. We want it on 29th.
hearing day.
That is 27th was Tuesday.
If you-
53.
Yes, what is this?
Petitioner is the agent of a cooperative society, Lordship.
Ah.
A retailer license was issued to her by the Assistant Director of Food and Civil Supplies. And he is running her shop more than 100 beneficiaries, Lordship. So in that meantime, government.
Will not be issued directing the respondent to insert the license code of the petitioner in the RCMS. Here's what happened. What is the respondent number 4 saying? Stating that a petitioner's license could not be inserted in RCMS portal as per government notification for the present scenario of implementation of One Nation card.
The year 2022, Lordship, that's letter.
Madam, Mr. Counsel, why don't you file an affidavit explaining? If they say something like that, don't you think that you need to explain that this One Nation card should not be act as an impediment for you inserting it in your code? Don't you think so? File a reply. Otherwise, I'll have to dismiss your petition. Mr. A.Z. Ahmed, appearing on behalf of the petitioner, seeks for some time for filing an affidavit in reply to the affidavit in opposition filed by the respondent number 4. List the matter again on 9th line of September 2024. The affidavit in reply be filed by 5th of September.
Before.
May please.
Matter pertains to the land valuation of in the district of Ujjain.
Washing and setting aside the zonal land values of Hosai. Affidavits filed. Yes, government.
I am yet to receive instruction.
2022 matter is yet to receive instruction. How is it possible?
Lordship may grant me some time, Lordship I'll.
Mr. B.J. Talukdar, the learned counsel appearing on behalf of the respondent, submits that he would get to receive the instructions, taking into account that the writ petition is of the year 2022. And and almost 2 years have passed by. This court, for the ends of justice, grants an accommodation to the respondents to bring on record their stand by way of an affidavit as a last opportunity. List the matter again on 23rd of September 2024. The affidavit be filed on or before 17th of September 2024. File your affidavit.
Okay.
25.
In this case, I prefer 10 more days, Lordship, to file my affidavit.
The S.S. Roy, no? Appearing on behalf of
The respondents.
Union of India.
No, Lordship, 225.
Huh?
225.
225 submits that he may be granted 10 days time for filing the affidavit. List the matter again on 13th of September 2024. The affidavit be filed by 5th of September 2024. The petitioner, if so advised, would be at liberty to file the reply.
Oh,
Yes, government.
I have received the. Says 10.87 meters. Open. Calculating from the roof of the basement of the height of the shade is 1.
Yes, how much should it be?
7.5 meters. 7.5 meters. The permissible.
10.487. Yes, what do you have to say?
Fine, I am, my lord.
For what?
For, respectfully with all humility, my lord. For modification.
Mr. Datta. See, you are a private person.
My lord.
If it is 10.35 or 10.87 or just for example, it is 1 feet more, 1 meter more, how does it affect you?
The entire thing will
And
rotate on a
if
wrong.
if it is a case of a private dispute, this court is not going to touch it. The court have already decided this. Kindly see your bona fides. You have come up that they have taken a 4-storied or a 5-storied building in respect to a land which could not have been.
No.
No,
No.
initially.
No, we are challenging the entire construction permission, having so many violations.
Whatever maybe, you came up at that point of time that took care, they had 4 or 5-story building permission in respect to a land which could not have been there. This court says that its height cannot exceed 11 or something. And in accordance with that, the authority said that, okay, this is the height which is permissible, you cannot go beyond that. Now, this court have come up and said that it will be taken from the basement, parking from there, and you see from the height, taking into account that in the case of a parking in the ground floor, only 2.5 meters is permissible.
Basement.
Basement. If you have a basement, then the height will be taken from 2.5 meters. We see the municipal.
2.7 meters. Hey,
Now, under such circumstances, don't you think that if we are limiting that, they are saying at 10.87, don't you think that there's only direction should be passed that they should not increase any height beyond that?
my God.
Unless.
I'm on the different footing. I'm not saying.
No, I'm not on a different thing. Only this is on the question that 10.87 or whatever may be, what is required is whatever height they have reached, that is the limit and nothing more.
Therefore, my lord, please kindly give me a 1 minute time. The height of the building has to be measured from the road level. And had it been done, then the height of the building would be different. And that is the measurement to be taken. Because if it is on the upper side, then naturally it will be reduced. So therefore, that matter to be
Just for
considered, my
example,
lord.
if we are going to take from the road level,
Yes.
tomorrow the road is height goes increase.
No, therefore, the permission itself says that the measurement as per the statutory norms, it has to be taken from the ground level.
Ground level, it's not said road level.
No, then therefore ground level.
No, ground level will be different.
No.
Mr. Dotto, kindly appreciate, a road may be below a particular height of the land. In Guwahati, I don't know other places, in Guwahati, you find lots of lands which is at a higher pedestal than the road, taking into account the floods.
Kindly hear me. Therefore, in the building rules 2014, the building's heights has been defined. And in the definition, it says that whatever the ground level is there, that has to be taken into consideration. Whatever the ground level.
But how does it take care of that other one? That if you have a basement parking?
No, even if the basement parking, the height to be calculated from the ground level.
No. That is not what it is there.
The Lordship kindly hear. So far, Lordship, on the last occasion, we dealt with the matter, and in that deliberation, Lordship was kindly have a note that in the section 54(7)(b), that is in respect of steel construction. Lordship will find the steel construction, that is our High Court's parking. That is the steel construction. That is not in relating to the basement parking, my lord. That is the semi-basement basing upon the construction over the stilt parking. That, Lordship, kindly hear me, I am not on that part, Lordship, whatever the matter may be, but we should be on the right footing. That I am only to assist this honorable court. This is only in respect of the steel construction. Steel construction is, this construction is on the, over the pool or the pillars. It is not in respect of the basement parking. And therefore, the earlier also, the measurement has to
Are
be
you
taken
saying,
on the ground level.
are you saying that the basement,
Lordship.
the floor of the basement has to be the flo-
Underneath.
No, height of the floor of the basement has to be with the road level?
The basement is underneath, Lordship.
No.
Underneath,
No,
and
no,
the ground level.
I'm not on that. Are you saying that the basement floor roof has to be with the ground level,
No,
road level?
No,
Show me that.
no. Oh, so sometimes, because Lordship will find in section 54(7)(b), it says semi-basement. Now, what is the semi-basement? My respectful submission, Lordship, kindly appreciate that our High Court building. Now, our High Court building is a steel foundation, it's a steel construction. Now, semi-basement is, Lordship will find that when the steel, this parking is having some downwards, that is semi-basement, my lord. That is semi-basement. So it is in respect of not the
Mr.
basement.
Doctor, I'm asking you a specific question.
Lordship.
Do you mean to say that the roof of the basement parking and the road level has to be the same? That's it.
The basement definition also there.
No, no.
In the,
No, does it say that the height of the basement floor as well as the road level has to be same?
now,
Show me that.
in
No,
the tilting height.
No. What I have ordered is that kindly measure from the roof of the basement
Correct, Lordship.
to whatever it's the height.
Correct.
Now you mean to say
It is
that
upper than the road level, ground level. The
no,
question,
therefore I'm asking
the
you.
difficulties is, my lord,
No.
the basement, roof of the basement is upper than the height than the this ground level. Now the height of the building has to be measured from the ground level, my lord. Height of the building can, with all
Understood.
respect, my lord, it cannot be.
No, kindly show me one thing, that the basement's height has to be in parallel with the road height. Show me that.
No, basement
That is the only answer, because this is what I have done. I
No,
say that no, Mr. Dutta, I have only said that the basements from the basement floor's roof, you may examine the height.
With all respect, with all humility, we may on the wrong footing. I'm with all respect to this.
Mr. Dutta, if you
I'm
say,
here
no,
only to
no,
assist this
no, I'm not on the other thing. I'm only asking you, can you say that the basement floor, the roof of the basement floor has to be in the height of the road? Show me that.
Basement, I'm just coming to basement.
We'll have it next week. Next on a Tuesday.
Lordship, kindly give me a permission that the report may be also furnished to us. We may respond to that. That only permission leave is to be there.
No response business. What response? No response business. The report, you want a copy, they will give it to you.
Yes,
no response.
of course.
The height and measurement, this is only a one line, they have measured it out there.
Yes, on 6th of September, my lord. I understand.
Show me only to that effect that the height of the basement floor, the basement roof, and
the
road
level
has to be same.
Has to be same. I will come back on 6th September, my lord. Kindly permit me. Other than my personal assignments, I think. Out of
10th of September.
6th.
6th is the Thursday.
No, Friday.
Friday difficulty. This
Friday.
matter will take some
On
time.
5th, Lord, 5th. Let us try, man. On 5th. Let us try.
Pursuant to this court, this court have passed an order on 2024. Whereby the District Commissioner Tinsukia was directed to carry out the measurement of the height of the building as per the observations made in the said order. In pursuance thereto, a report has been submitted by the Additional Deputy District Commissioner, bracket ULB Tinsukia, including the report of the building, a report of the, including the report containing the measurement. From the said report, it has been found that the height of the building from the roof of the basement parking is 10.87 meters. The said report is kept on record and marked with the letter X. So Mr. BJ Talukdar, appearing on behalf of the respondent state, shall provide a copy of the report to Mr. S. Deka, who appears on behalf of the respondents.
6 and 7.
7 and 8.
7 and 8.
Is the matter again for further consideration on 5/9/2024.
Grateful, my lord.
My extremely kindly bits. Interim order waiver.
The interim order passed earlier shall continue till the disposal of the litigation. Yes, Mr. Sinha. What is this?
Lordship, some more time may be given to file affidavit, Lordship. We have not received any instruction, therefore affidavit could not be filed.
Why does it take such a long time for filing affidavit? Are they be appearing on behalf of the respondents seeks for a further opportunity for filing reply? So it is seen that on earlier occasion also the time have been sought for. Under such circumstances, this court fixes this matter again on 25th of September 2024. Is directed, the respondents are given the liberty to file their affidavit on or before 17th of September 2024. The petitioner, who advised, would be at liberty to file the reply.
Obliged.
Yes, Mr. Bugasta. Oh, your matter. Necessary steps for allotment of the land measuring 8 bighas covered by so and so in year based on continuous possession and regular revenue payment. Yes, yes.
My lord, I am really sorry, my lord, because I have not gone through the brief today itself. I have been requested to.
Okay. Mr. A.K. Purkasta, the learned counsel appearing on behalf of the petitioner seeks for an accommodation as he is not prepared with the matter stands adjourned to be listed again on 11th of November 2024.
Obliged to you.
Party. Yes, what is this?
Non-payment of contract.
Why is the non-payment here?
Lordship, we have filed our affidavit, your lordship. Lordship, we have stated that we have paid our share, the state share, your lordship.
Oh, that one, water resource.
Yes.
Jal
Jal
board
Shakti.
made a party. Jal
Yes, sir,
Shakti.
Jal Shakti is a party here.
What does the Jal Shakti say? No Jal Shakti member. Have you paid your amount?
Yes, your lordship.
Your share, have you got state share?
Paragraph 6, we have stated that state has already paid its share, Your Lord.
Deluxe 40,000.
Pustap. None appears on behalf of the Union of India on call. Pustap. It is also seen from the affidavit filed by the respondent state that the state share of 10% have already been disbursed to the petitioner. Under such circumstances, the issue remains as to whether this court is required to issue appropriate directions for upon the Union of India for disbursing the 90% remaining 90% of the petitioner's entitlement. Full stop. For the ends of justice, this court adjourns this matter, taking into account that the Union of India is not represented. Full stop. List this matter again on 30th of September 2024. A final opportunity is being given to the Union of India to file the affidavit on or before 23rd of September. It is made clear that no affidavit is filed. This court shall proceed to dispose of the instant petition on the basis of the materials available on record.
Right.
Land grabbing? Why this?
Because special appellate tribunal, no, my lord.
Why land grabbing?
Land grabbing, my lord, there are allegations
Writ
for
petition, why? 226.
special appellate tribunal not formed yet, my lord.
226 not there, 227. File 227. I can't convert this. You can convert this 226 to 227. State of Assam has no business. Do you have to be against this person, debacle? Withdraw and file a fresh one. Period during this, I'll exempt it. The instant writ petition has been filed challenging the order dated 31/2023 passed by the learned additional district judge Gwalparai in land grabbing case number 30/2014. The learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition with the liberty to file an application under Article 227 of the Constitution. Taking into account the above, the instant writ petition stands closed on withdrawal. However, petitioner is given the liberty to file an application under Article 227 of the Constitution, challenging the order, judgment and order dated 31/2023, passed in by the learned additional district judge Gwalpara in land grabbing case number 30/2014. The period from the period that is from 11/4/2023 till date be excluded while computing the period of limitation. None appears on behalf of the petitioner on call. Stop. Matters stands adjourned. For the ends of justice, the matter stands adjourned to be listed again on 2nd of December 2024. In the meantime, stop. It is however observed that if the petitioner is not represented on the next day, this court shall presume that the petitioner is no longer interested in the instant proceedings.
34.
May kindly see the order dated 15/7/2024.
Yes, respondents affidavit filed. Everybody.
Not filed, my lord. My lord,
You
we
have
have
filed?
filed one affidavit, and additional affidavit is required for certain clarification. But just brief background.
No, you want to file an additional affidavit?
In
Mr. P. Bodloy,
my lord, P. Handicman,
P. Hendik, appearing on behalf of the respondents.
PNR.
PNRD Department 6. An accommodation for filing an additional affidavit, bringing on record various additional facts. First, taking into account the above, list the matter again on 29/2024. The affidavit be filed on or before 13th of September 2020.
It's not bad. They will clarify the paragraph 18 and paragraph 10 of the DPP. They file affidavit. They should clarify the paragraph
File
18
an
and 10
additional affidavit clarifying
as
the
ordered by the
earlier
Supreme
stand taken in the affidavit.
Court. Affidavit in against the paragraph 18 and 10 of the DPP.
They file an additional affidavit. Stop. At least the matter he took only, huh?
Please, Your Lordship. In this case, I am appearing for Respondent 6, Lordship. We have filed affidavit in opposition on 9/8 of this month. Here it is not take with the record, Your Lordship. I have filed affidavit in opposition, Your Lordship. It is not in the record, Your Lordship, on 9th.
You are appearing for?
I am for Respondent number 6, Your Lordship, and it's ADCL.
The so-and-so appearing on behalf of the respondent number 6 submits that the affidavit in opposition has been filed on behalf, have been filed. However, the said affidavit in opposition is not on record. List the matter again on 4th. 4th খুলে বন্ধ September. On 9th of September 2024.
Please, Your Lordship.
Yes, what is this?
I have a plot of land measuring 3 acres. And it is taken by the Water Resource Department and constructed embankment without acquiring the law, acquiring the land, following the due process of law. And the compensation is also not awarded. When I filed the writ petition, they have communicated me and
When was your land taken?
in 2012.
Yes, government, what is your stand?
Lordship, I am appearing for water research. As per my verbal instruction, we are preparing for returning his land, Your Lordship, because the project has been abandoned now, Your Lordship.
When did you take the land?
Lordship, it was stated in 2021 in the petition.
Page number 4 of my affidavit in reply. It is there later issued to me, as well as they have issued to the circle officer also. It is stated in the 2012.
Page number?
Page number 4 of my additional,
No, 44.
my reply affidavit, in the one an exact.
We do not receive that.
It was done in 2024. No, I'm not that. If your stand is, have you filed an affidavit?
No, Your Lordship.
Yeah, they have filed affidavit.
What you have not filed it? Very new, have you stated that you don't want this land?
Nothing is there.
Huh?
Picture of my friend and the stand taken in the affidavit. Does that match?
You made a PWD party.
PWD land is taken by the North Lordship.
Huh?
PWD is not taken. Additional Deputy Commissioner.
Now, if you see page 29, running page 29, or the affidavit which have been filed by the Water Resource Department, kindly see 2 and 3. Kindly see page 29 or running or page internal page 8. E. It is also made clear that earlier when the embankment was constructed, no land was acquired following due procedure. The same embankment for so-and-so was handed over to the PWD Roads Department dated so-and-so by the Water Resource Department and is taking work on the so-and-so. Then
That statement is contradictory because I am not aware about the land is handed over to the PWD department. This
No,
communication,
whom should I direct?
this is latest communication is there. At the page number 4 of my reply.
No, first of all, Mr.
Is issued on 3.
There is a running page. If you don't have running page, don't say. There's a running page concept in the petitions. There is no page number 4 business. You are referring to annexure A of your affidavit in reply. This is only said by the executive engineer what Guwahati East. Why is he writing this?
I do not receive any copy from my learned.
I have
friend of the
given
affidavit
everything to
reply.
them, even then my friend has submitted, they did not file affidavit when I.
How is it
And
that he will file without giving you a copy?
Lordship, and the affidavit which he referred is filed by Deputy Commissioner, Your Lordship, not by Water Resource, Your Lordship. Affidavit in opposition.
And the
Water
deputy
Resource
commissioner
has
says something else. Well,
not
executive,
File anything till.
why
date,
you
Your
have not filed affidavit?
Sir, I will file, Your Lordship. Only today I have received verbal instruction that we are going to return the land, Your Lordship.
As per the deputy commissioner too, you have returned it to the PWDR.
There may be some contradiction, Your Lordship. Kindly allow some time, Your Lordship.
The stand which have been taken by the deputy commissioner. The stand which have been taken by the Water Resource Department. And as could be seen from a document enclosed to annexure A to the affidavit in reply filed by the petitioner. And the submission made by the council appearing on behalf of the Water Resource Department are all conflicting. Under such circumstances, this court fixes this matter on 23rd of September 2024. The Water Resource Department is given a final opportunity of filing the affidavit on or before 17th of September 2024. The Mazumdar, kindly see their affidavit of the year, wherein they say that they have given it to the PWD.
What is the statement they have made, but in fact officially has not been communicated. What is the status of my land? I have seen that there is an investment in my land. Accordingly, I approached the court. When I approached the court, they have communicated me.
Obliged.
Yes, what is this?
This 38, my lord. By this order, my lord, mutation was allowed in the name of private respondent number 4. Then we file an appeal. Appeal was allowed, my lord, saying that there is no document for mutation, allowing the mutation. And the circle officer was directed to take necessary action. And this 58, my lord, the appellate court order.
Then
Circular officer, my lord, thereafter review was filed by the respondent of 4. Review dismissed by granting liberty to approach them to civil court. Circular officer, my lord, is sitting over the matter. He is not correcting the record. And the instruction has been submitted, my lord, on the last date. The circular officer saying that there is no there is no specific direction to carry out the order. Therefore, he is not carry out. And he has
the
no.
mutation was granted in favor of the private respondent. Thereupon you filed an appeal.
We filed the appeal.
And that appeal was allowed.
Allowed.
And thereafter,
In the appeal, my lord, there is no strict direction to correct the land record. Therefore, my lord, he is not correct.
Appeal allowed means with what direction?
Appeal allowed, my lord, saying that there is no record on behalf of, on the, my lord.
The mutation was cancelled.
Not.
But then also he is not correcting the records. That is why you are before this.
I've received instructions from the circle officer, which says that the same plot of land measuring 1 kata 2 lechas, 1 kata 7 lechas 2 pua, that was mutated in the name of Dalimi Haloi, was also partitioned on 14/11/2019, and a new DAG was generated in the KP Patta number 489 of village needs Bongkhor in the name of Dalimi Haloi. The fact of partition and subsequent generation of DAG and Patta number do not find mention in the prayer before this honorable court.
He is not on that. Mr. Ahmed is a simple question.
Well, there's nothing.
When there is a,
nothing that-
when there is, his mutation of the private respondent have been cancelled by an appellate court's order, why is the name of the private respondent still in the mutation records?
The court never cancel our mutation. If your lordship can we see page number 60.
And 6?
60.
60, my lord. 58 is the order, my lord.
Order. Vernacular, my lord.
68.
Yes, it simply said that, my lord, there was nothing on record regarding the land of the private respondent. That's page number 60. 58. Vernacular. এইটো বুজা যায় যে দ্বিতীয় পক্ষৰ স্বামী বিপুল হালৰ নামত কোনো ধৰণৰ তথ্য দেখা নগল বিবাদীয় জমিত দ্বিতীয় পক্ষক এই গোচৰৰ চিভিল কোৰ্টত দিবৰ বাবে জনোৱা হ'ল the only direction was that you approach the civil court. There was no specific direction to the circle officer to correct.
After proper scrutiny of the case related. No, this is the different case. This is on review. Where's the first one?
Yes,
This is the only order.
That is the only order.
This is the order.
Yes, the deputy commissioner has issued this type of order, my lord, in appeal.
They should prefer an appeal before the revenue, my lord.
Yes.
Appropriate forum,
Revenue board.
revenue board.
What is this?
Finding, my lord, that there is no record for repetition and in the, my lord, copy to my lord. The circle officer is directed to, for information necessary action.
Where?
Copy to my lord, number 1.
Therefore, what is this order? My goodness, Mr. Ahmed. No case. To do. Have a case.
Against this order, my lord, review was filed. Review order, my lord, page 62.
Page
62, my lord.
62. Case is disposed of with a direction to the second party to
Yes.
file case before higher court. Who is second party?
We, the private respondent.
You.
Yes.
Yes, my lord. In
But
both-
without interfering with the mutation.
Nothing was done. They should
And the
prefer an
circle
appeal,
officer
my
was
lord.
directed to take necessary action.
That necessary action must precede some, my
Have
lord.
you challenged these orders? 24/5 and all these orders. 23/9. Hang on, list the matter tomorrow at 2. We'll dispose it of. Have you challenged these orders? If I had challenged these orders, I could have passed the direction. But this is not the manner in which the order is to be passed. Either you allow or disown to say that I'll pass an order like this. Yes, tomorrow at 2.
Highly obliged.
Yes, any more urgent matters?
Item number 44. There is a status court, and I'm going to appear in this case, my lord. So this matter may be, my lord,
Item number
44.
44 is a GST matter. What are you doing?
I'm going to appear, my lord, on behalf of petitioner.
What?
On behalf of the petitioner, I'm going to appear.
SK Singh, VK Chopra.
Yeah, my lord, I have the positive instruction to appear in this case.
Okay, what is this? 44, what is this matter, sir?
Matter raised to my lord, demand notice was challenged. And other days, my lord, lordship was of the view that there is an alternative remedy, and in view of the alternative remedy, perhaps, my lord, I have a different product. Order in origin as well as the demand notice was under challenge.
Hello. When do you want?
So, lordship, can you fix the matter?
You don't have a case from a perusal thereof.
Lord, on 16th of September.
What?
16th of September.
You are not going to practice during this period in the court.
Can lordship fix the matter?
Take it,
Yes, on
release this matter on 16th of August 2024. Interim order passed earlier shall continue.
16th of August.
16th of August.
My lord.
The case is for dismissal
My lord.
at 2 p.m.
At 2 p.m.
Prepare yourself.
62 interim order is still today.
Which one?
62. 62.
62. What is the matter about?
The circle officer has been issued a notice asking to produce some documents regarding petitioner is the owner of a plot of land by virtue of a gift deed executed by his grandmother. The elder brother of the petitioner has lodged a FIR before the Itanagar police station stating that the gift deed is false.
Did I deal with this matter?
Yes, Lord.
Yes, sir. 62.
The last occasion, we are directed to take dusty service and we have taken and although affidavit has been filed. Lordship. Paragraph number 7.
What has happened to the mutation case? I remember this case now.
Yes, sir.
Because Mr. Dida submitted that in spite of that, they are trying to disturb.
Yes.
You are appearing. Okay. This matter again on. Does this service done?
Yes, sir. We have filed a affidavit. On 5th of August, notice has been received.
Who is Sangeeta Chaudhary?
Wife, Lordship.
In pursuance to the order dated 37/2024, in that the service of the copy of the service was have been effected upon the respondent number 4 by way of Dusty, and in that regard, an affidavit of service have been filed. It is also seen that this on behalf of the respondent number 4, his wife have duly received and put her signature. Considering the above, the service with the respondent number 4 is deemed to be complete. List the matter again on 19th of August, 2024.
Other date may fix, Mr. Senior Counsel, Mr. Didas will be not available 19 to 22.
When is it not available?
19 to 22.
Okay. 19th of August 2024. Interim order passed earlier shall continue till then. Don't ask adjournments on senior counsel.
Right, number 38, the interim protection is
Give me another date when he is not available, I'll put it only on that.
interim to continue.
Interim order passed earlier shall.
Right, number 38, the interim order is still today.
30?
8.
Yes, skip today. I had it only till 37. What is that matter?
We were the persons who
It-
went
it-
without objections, nominations were also accepted. And without contest, we were there. The rest of the group challenged, not us, but they said that their rejection of nomination is bad in law. Point which fell before your lordship was that whether there were 5 in all or total numbers were more.
Oh, this one,
Yes.
total
They filed an
15.
affidavit saying that all of them had filed the appeal. But when I read through the contents of the appeal, the order,
No, I remember only 5 has filed or something.
that was the thing. If it is 5, then it's okay. But if it's the total group is there, then possibly it might be a different scenario. But they filed the appeal with the so that they bifurcated 2 groups, 5 and 4. It is apparent, lordship would hold, otherwise I do not know, that they pressed for 5 and not for the 4. If they pressed for 5, then there's a waiver so where 4 is concerned. That's my case.
Pursuant to the order dated 29/7/2024. The affidavit has been filed by the respondents, private respondents.
10 to 7.
Private respondents. State or the private?
Private.
Private respondents as well. An affidavit has been filed by that private respondent. Additional affidavit has been filed by private. List the matter again on 29th of August 2024 at the top of the list at 2 p.m. Interim order passed earlier shall continue till then. I have heard this matter.
Yes,
Sir
yes,
Colonel.
Dr.
This is the only point. Then if it is more than 5, then the election has to go.
I'm arguing doctrine of waiver. That's
That is
that's all.
Any more? Yes, Mr. J.M. Chaudhary.
My lord, item number 58 of supplementary list. The last question, my lord, before that also, my lord, an order was passed to consider the interim order, my lord. And lordship also passed an order on last occasion. So today
Always
is, my lord,
happens at the
lordship may
last
fix it
moment.
on Friday, my lord, if possible.
Huh?
Maybe if it possible, my
The
lord.
58th to list the matter again on took yes, 16th,
Lordship, Friday.
16/8/2024, and on which date the interim order shall be considered.
Item number 43, lordship.
Yeah.
We'll file our reply. The respondent number 4 has already filed their affidavit. Time may be granted.
Fine. Nobody is asking you. No problem. What do you need? Any interim order extension? That is a different thing. Why? Anybody? Yes, Mr.
My lord, my case is supply 60 lordship. This is a contempt matter, lord.
60.
6G.
Uh,
So, lordship, last occasion, India has fixed the dates.
Huh?
Last occasion, lordship has fixed the date today, lordship. So Dinath was on that day was not present. Dinath's name is already reflected.
they also did not there.
So next day maybe fixed,
To
lord.
62, list the matter again on 30 August.
Right, lordship.
Wait, please, my lords. It's item 39. I merely pray for a date in this matter. This was
30?
39.
Yes, what is there?
My lord, that this was regarding extension of my tenure as chairman of the Regulated Market Committee. The Agriculture Department has taken a contradictory stand. Earlier, before the Honorable Court had set a timeline in which our election would be
Affidavit
scheduled.
is filed.
My lord, yes, the affidavits have been filed.
Both.
But the affidavit that they said they would file, they have not filed. Now they have resigned from the statement saying that we cannot hold the election because the voter list cannot be prepared. My lord, now I am hanging.
Oh, that matter.
Yes,
Ah, where they say that now, earlier there was a direction.
yes. A
by
clear
this court.
timeline was given. And
Now
they've
they
taken
say
the-
that they cannot.
Yes.
There he appears.
Yes, for marketing board.
Ah.
Filed by the department of it.
My lord, this can be taken for disposal perhaps.
39, list the matter again on 2nd of September 2024 at the top of, at 2 p.m.
Obliged.
Your lordship may kindly in items 40 and 41, your lordship had directed the respondents to file affidavit, your lordship. It pertains to rehabilitation of evicted persons of Goruguti, your lordship. There has not been any affidavit filed yet, so your lordship may kindly direct them to file the affidavit a little expeditiously.
They don't file the very good. We'll have some other date.
They are not being rehabilitated, your lordship. You have been evicted already.
40 and 41. Oh, those matters. Stop. 40 and 41, Leho. It is seen that the respondents were directed to Revenue Department of the Government of Assam was directed to file an affidavit. However, no affidavit has been filed. Under such circumstances, this court fixes this matter again on 9th of September 2024. A final opportunity is being granted to the Revenue Department to file the affidavit on or before the next date, taking into account that this court had specifically directed to file an affidavit clarifying a particular aspect of the matter. If the affidavit is not filed, this court may consider calling for the personal appearance of
Revenue, your lordship had also directed the district commissioner, so that.
Commissioner, lordship, there some instruction has been received.
the district commissioner. Consider filing up here. Personal appearance. By 9th of September.
Much obliged.
May I please, your lordship? Item number 48.
Yes, what is it?
Yes. This is an interlocutory application filed in CRP. Seeking day of the execution proceeding. Execution proceeding next date fix is 21st. So earlier this matter came before your lordship.
Why the matter is before me?
Before the lordship for admission. Ultimately, LCR was called for and it has been received. And it is now ready. So, however, this stay prayer was, your lordship, that was not granted. And because of that stay, execution is also going on. So it's a decree under section 6 of the specific relief type on the basis of possession. And the decree was, obtained on the basis of one document, which according to us not proper. It is
But why this matter take with me?
yes, it was, at the initial stage, this came before your lordship.
Understood. Many cases come, but does it mean that the matters would be take with me? Why is the matter take with me? Detail 48 to list the matter again on 19th of August.
19th.
It is filed over to. Take Jodi Mulogod Nai. Mulogod Jodi take with as this court is not taking up the roster. List the matter before any other bench, before the court holding the roster of bench one. On 19th of August at the 19th of August.
If probable, and then 2 o'clock possible.
No,
Otherwise,
19th of
very
August, if
limited
it
time
is
is
with
available.
me, and if it is not, যদি মোৰ লগত take হৈ আছে কি হোৱাৰ কাৰণে হৈছে চাব list the matter on 19th of August at 2 p.m. যদি মোৰ লগত take হৈ আছে তেতিয়া I will.
Number 42, Lordship.
Yes, what is it?
It is it is about the distribution of PDS article. So pleadings are complete. Any date it is listed on my request, Lordship. Any date as per convent. Convent of the court. I'm praying for a date, Lordship.
I'll get a date from him in the month of September. Yes.
So item number 61, my lord, I am eligible 17 years regarding the matter land acquisition matter compensation about 2003 matter. So
60?
61, my lord, supplementary. Today was date fixed for my lord reflecting the name of the water resource department, but same was not reflected, though I could be served on that the last occasion.
It was not reflected.
My lord, yes, sir.
61.
61, my lord.
Yeah. This court by an earlier order directed the registry to show the name of the water resource department in the cause list. However, the same has not been reflected. The registry shall do so. Shall list the matter again on 308/2024, showing the name of SC Water Resource Department.
May I please? Your Lordship, I'm in item number 49 and 50. My Lord, we have filed a preliminary affidavit. I'm appearing on behalf of respondent number 4 and 6. I'm praying for a matter be listed on a Friday. My Lord.
Why?
Lord, this is a case where in terms of the last order, directions were given to us for the auction of a tea estate in both the matters. We have subsequently we have auction sale the tea estate, but this the another in item number 50. This is being hampered. The auction has been stalled because the petitioner bank has subsequently taken the possession of the tea estate, and they filed a possession notice in item number 49 and 50.
Same garden, different.
Two different garden.
Okay, 49 and 50, let us be listed on Monday, 19th? 19th? At 2 p.m.
Be clear.